This time we'll call to order on our regularly scheduled June Board of Adjustment meeting for Buncombe County. Welcome. We will start with staff announcements.
Yes, I just wanted to let you all know that appeal was a petition for a writ of certiorari was filed in the Emma Road SUP case. So that case has been appealed and is currently in Superior Court. We are working on preparing a record and filing a response. So I just wanted to give you all a heads up that that decision was appealed.
Thank you.
And
Has
it
been
was the, well, obviously, it was the Emma, people with the standing individuals who were the ones appealing.
Okay. All those standing parties were included in that, you think?
I believe so. I think whoever Mr. Knorr was representing, so.
Has it been calendared?
No, usually when a writ or when a petition is filed, usually the clerk issues what's called the writ of certiorari. I receive a copy of that, then staff has 60 days to prepare the record on appeal. Then we submit the record on appeal, and then the parties will ultimately file briefs and make arguments before, and then schedule a hearing before the court.
Okay, perfect. Thank you for that.
Sure thing.
Moving to roll call of board members, we'll start with Mr. Mazelis.
Yeah, Joel Mazelis.
Paul Wilczynski.
Craig Allen.
Andy Ball.
Catherine Morsani.
Thank you so much. Staff?
Savannah Glantz.
Kurt Ehler.
Griffin Kearns.
Thank you. We have meeting minutes to consider from one meeting. Is that correct, Griffin?
It is from two meetings. It is from the April 28th special meeting and the May 14th regular meeting. And I do want to note that the original draft of the April 28th minutes that I sent out yesterday did have an error in it, and I sent out a corrected copy this morning with that error corrected.
Okay, thank you for that. Has the board have time to review those or to look at those? Yeah.
Did just the closing comments from the last meeting regarding attendance. Would it be worthy of talking about that a little bit? As I looked at those notes, I wasn't here, but as I looked at those notes, I just wonder whether, for some members of the board, I can speak for myself. I can tell you for the next 12 months when I won't be here, because the only time I won't be here is when I travel.
Yeah.
And so if we could get those things already identified, if anybody else has a calendar where they know they're not going to be here, let staff know and have months of advance notice.
It's a great point. I think we had maybe 20 minutes of discussion at the last meeting on this, and we sent out an email today as well. But let's get to that item after our caseload today, if that's okay with the board.
Okay.
Do that, yeah. We'll move to disclosure of ex parte communications at this time. We'll start with Mr. Mazelis.
None.
No.
No.
None? No.
No.
Just if
Thank
I
you
can
so
say,
much.
I don't believe you ever made a motion to approve the minutes.
Yeah, we breezed right through that, didn't we? Let's move back. Let's move back, by the way, to, well, closing that ex parte communications section up. We have no ex parte communications that we've heard, so we'll check that off here.
Motion to approve the
Moving
minutes.
back,
I'll second.
we have a motion to approve both sets of minutes and a second as well. All those in favor, please say aye. Aye. Any opposed, nay? That motion passes. Thank you. Appreciate that, staff. All right, moving to public hearing section of our agenda. A reminder for the public, this is a quasi-judicial hearing. That means that similar to a court hearing, state and local law set specific procedures and rules concerning how this board must make its decisions. This board's discretion is limited. We must base our decision upon the competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on the facts presented. If you'll be speaking as a witness today, please focus on the facts and standards and not personal preference or opinion. We value a transparent process and encourage the community to remain engaged and participate. But given this is a hearing on the record, there are certain topics and areas that limit the type of testimony we can receive from members of the public without standing. Expert testimony, therefore, is defined for certain topics as Opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic stemming from the proposed project. Individuals providing expert opinion testimony must be qualified as experts and provide the factual information upon which they will base their expert opinion. With that, we remind folks who are considering whether they should assert standing in a particular case, whether they indeed qualify for that, or whether they'd like to speak as a witness at the later part of each case. And we'll remind members of the public, and remind board members as well, that we will try to silence our phones or to put it on airplane mode during the hearing to avoid interruptions. And from there, we'll move to.
Sorry, speaking of interruptions,
Yeah,
I have to make another one. I did want to ask if anybody is present here regarding the AK and RS investments variance, the second item on the agenda? No, okay. So we will, if it's all right with the board, we'll wait to consider that until the end,
Okay. Today.
since the applicant is not here, and
Okay.
we'll have to have kind of a discussion around that one. So,
Give them some time.
Yeah.
Okay. We'll start with ZPH 2025-00017, the Gonzalez variance. This is continued from our May 14th regular meeting. And we have planning coordinator reviewed by Savannah Glantz.
please raise your right hand and state your name.
Savannah
Do you
Glantz.
swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Good afternoon, Board.
Welcome.
I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with the general statutes and county code. And I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objection, so accepted.
Thank you. This is the review of ZPH 2025-00017. Applicant is Jorge Gonzalez, who is the property owner. The property is located at 2 Hazelwood Road in Asheville, and the total acreage of the property is 0.37 acres. It is serviced by sewer and public water. The property is zoned R3 with no overlays present, and the applicant requests to reduce the front yard setback to 0. In this case, the applicant did complete all necessary steps and application processes to correctly place the home on his property in order to meet all standards outlined in the Buncombe County ordinance. To no fault of the applicant, a county site plan review approved the plans with the incorrect setbacks for the zoning district and allowed the applicant to move forward with the pulling of a building permit. As the home is already placed on the property, it would create an undue hardship on the applicant.
Are there questions for staff on this application?
So there is no question that the error was borne by the county?
Correct.
Okay, thank you.
Any other questions for staff?
Do you have any issues if it goes forward as is?
No.
Given that it was the county problem?
No.
Do we have precedent for this in terms of errors on the part of the county? I'm just curious, again, we have the ability to follow or not follow precedent, but
Not off the top of my head. I'm more than happy to look at that when I get back to my computer, but I'm
Right.
not aware.
I was
of
just
any.
curious. No need to look at it. Thank you.
Okay.
Just normally, if the county, the county does make mistakes on time to time or does commit errors on time to time. That is not necessarily allows, for an automatic variance or an automatic thing. However, that can be used in your decision as to why there's a hardship or the reason as to why there is the need for the variance. And once again, I think we want to be clear in this case that it was not the fault of the owner in any way, shape, or form.
It's happened before. We've seen it 2 or 3 times over the years. It's not often, but it does happen. So, hearing no other questions, thank you so much. We'll ask the applicant or the representative to come forward. And I guess up here is fine. if you want to stay at the dais. Here. Yeah. Mhm. And we'll start with the swearing in.
All right, please raise your right hand and state your name.
Jorge Antonio Gonzalez.
And do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome, sir. Thanks for being here today.
Good afternoon.
If you want to go through, through the reasoning why we're here today and take a look.
Yes.
You
need to Yes.
speak louder because I can barely hear you.
Okay, thank you. Good afternoon. Basically, I bought a piece of property, put a mobile home on it, went through all the permitting, zoning, was approved on both the permits and the zoning to do as I put down on my permit. Got everything approved, moved forward with it, and at the time of my CO, I was informed that I was not within the setbacks, but I had got approved prior to it. I did everything I was told to do. Yeah.
Thank you. Any questions from the board?
So what's your request to us today?
0 setbacks, please.
Please.
You said this one before planning and zoning, they said everything was okay.
Yes, sir.
Do you have any documentation regarding that?
I should have everything in the computer where the applications were filled out.
And Joel, if I may, we do have the approved site plan in our system that does have the stamp of approval by the plan reviewer, the staff member that approved his site plan with the incorrect setbacks.
Ms. Glantz, did the applicant place the mobile home in accordance with that site plan that was approved?
Yes.
Okay. Anything else? Any other questions before we close it up and deliberate as a board? It's pretty clear what happened here, I think, and county approved the plan, well, we'll start that discussion in a minute, but anything else you wanted to add to this?
That'll be it. Thank you.
Anyone else you wanted to call up? Okay,
Thank you.
great. Any other questions from the board again? Okay. Anyone else from the public who wishes to speak as a witness on this? Hearing none. Thank you so much, and we'll
Thank
close the
you.
public hearing. Thank you.
Good afternoon.
Open for board discussion and deliberation.
I think this is pretty clear, and looking at the map and the site map and the staff recommendation, I think he did everything he needed to do, and I don't see any reason why not to grant this.
I agree.
We've got a county error here, and
Yes.
any action to sort of force the rule here would incur a cost, I think, to the property owner. That would be undue burden, right? Undue burden, yeah.
Well, I also think it's the right thing to do, and if you look at it, there's, no one's here to protest it. You look at it, it's fine. You know, it's not the worst thing.
We've seen worse.
I don't have a motion sheet, but I would love to make a motion.
Should be one on each side here, next to, yeah.
Okay. All right, Mr. Chair, based on the evidence presented to this board, including the following exhibit, the petitioner's application, the submitted plan, development plan, GIS map, the staff report, testimony presenting the hearing, I move that this board adopt the following findings of fact: that this matter was properly advertised, is within the board's jurisdiction, and is ripe for its consideration, that this application, together with the condition proposed by staff and/or board and agreed to by the applicant, if any, does meet the requirements for granting a special use permit. Is that the one? No, that's totally not. But it's a variance.
variance script,
It's a
yeah.
completely different,
See
sorry.
if I have a variance.
Oh, here's a variance one.
Okay.
And let me get the, all right, so Mr. Chair, based on the evidence presented to this board, including the following exhibits, the petitioner's application, submitted site plan, GIS maps, the staff report, testimony presented at the hearing, I move that this board adopt the following findings of fact: that this matter was properly advertised and is within the board's jurisdiction and ripe for its consideration, that this application, together with the conditions proposed by staff and/or board and agreed to by the applicant, if any, does meet the requirements of granting a variance contained in the Buncombe County Code of Ordinances, Section 786214.
I second the motion.
A motion and a second. Any discussion? All those in favor, please say aye. Aye. Any opposed, nay? That motion passes.
Okay.
Motion.
Based on the foregoing findings of fact and for the reasons set forth therein, I move that the requested variance be approved and that staff be instructed to draft an order consistent with this motion approving the permit with any agreed-upon conditions for review and executed by the chair, acting chair, or such person's designee on behalf of this board.
There's been a motion. Is there a second?
Second.
All those in favor, please say aye. Aye. Any opposed, nay? That motion passes. Thank you so much.
Oh, and I was an aye if I didn't say it. I think I said it in my head.
I think I heard you. I don't know if I heard you. Yeah. I heard enough volume to be 3 ayes over there.
This one should be pretty quick. Mr. Chair, members of the board, here would be our proposed order that this is for a variance reducing the setbacks from 20 feet to 0 feet for PIN number 9639-227811 for property owned by Jorge Gonzalez and his wife Lorena. And that this is basically the board, it's ripe for consideration, notices have went out, that this is being done pursuant to Buncombe Code Section 78-621 and 78-642, that the applicant and everybody had an opportunity to speak, and that the unnecessary hardship would result from a strict application of the zoning ordinance. That the hardship does not result from, or that the hardship does result from conditions that are particular to the property. The hardship did not result from actions taken by the applicant or the property owner. This variance request is consistent with the spirit and purpose and intent of the ordinance, such as that public safety is secured and justice would be achieved by granting the same. There are no additional conditions for the variance, so based on the findings of fact, the board makes the following conclusions of law: that the application satisfies the requirements for granting a variance contained in the Buncombe County zoning ordinance, and that based on the findings of fact and conclusions of law, the variance is granted as requested by the applicant.
All right. We have an order.
Okay, I make a motion to approve the order.
Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? That passes.
Thank you.
Thank you so much. I'm going to move next item on our agenda, which is ZPH 2025-00004, the Stern Stormwater Variance. This item is continued from the May 14th regular meeting. We have Savannah and Victoria here from staff. Brian.
Hello again. I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance to the general statutes and county code, and ask that all applicant and staff materials be accepted into the record as evidence.
Seeing no objection, those are so admitted.
This is the review of ZPH 2025-00005. Applicants are Betsy and Alan Stern, property owners. The property is located at 99999 Old Fort Road in Fairview. The total acreage is 10.1 acres. It is serviced by well and septic. The property is zoned open use and is within the steep slope overlay, and the applicant requests the allowance of a driveway to encroach into a 30-foot stream vegetative setback. Note is that the access to this property is limited to a deeded right-of-way that is less than 30 feet landward of the surface water. Topographic constraints do not allow for alternative access, and the neighboring landowner is not willing to consider an alternative right-of-way into the property. This variance would allow access to this property.
Okay, open up for board questions of staff.
Question. So Savannah, basically what you're saying is he has no other choice than to do this plan.
That is my understanding of the variance. I will say for any technical terms, since I'm not in the stormwater world, we do have Victoria Hoyland, who is the stormwater engineer for the county, should the board have any questions as well.
Do we know when the right-of-way was granted?
I do not.
Can Victoria just share her stuff? I'm sure she has prepared remarks, right?
All right. Please raise your right hand and state your name.
Victoria Hoyland.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
I guess first, did staff work with the applicant on this plan, and was this one of the only or the only option here?
It is not, so it is not necessarily the only option. I would probably defer to the applicant's design professional on what alternatives were considered. It has not been concretely demonstrated to us to date that the application cannot be compliant with the stormwater ordinance requirements with other options
Okay,
considered.
we'll probably have more for you later on in the hearing.
Well, so then where's this plan failing the current stormwater ordinances from your point of view?
They are proposing a driveway within the vegetated setback in a manner that is inconsistent with what we typically will approve. To give some more information that might be helpful, this is in the stormwater regulations, there are low-density and high-density water quality requirements. This is a low-density project. And in low-density projects, built upon area such as a gravel driveway or a paved driveway or a building are not allowed within 30 feet of a stream top of bank to provide water quality benefits of that riparian buffer. We do allow by policy crossings of streams where there's a culvert put over the stream and the built upon area from the driveway does go into the setback, provided that those crossings are as limited in impact as possible, which means they are perpendicular or near perpendicular to the stream, and basically are getting in and out of that buffer as soon as possible. That is not what is occurring here due to the configuration of where the existing logging road, which was not gravel, it's just a soil logging road, where that was located and that's where they put as my understanding is where they put the deeded easement on the adjacent property. And that existing soil logging road is located in the buffer in a manner such that if it's turned into a gravel driveway, it will not meet the water quality requirements of being 30 feet away from or perpendicular crossing that stream. I hope that's
Yeah, thanks.
helpful, not too much.
That's clear.
Would you say that topography, though, of this lot would indicate that this location for the driveway is one of the most economical?
Certainly the most economical. I don't know if it is the only feasible it may be the only feasible. I have not done the review of the other right-of-way frontage on this property to see if it is possible to put a switchback driveway there. I'm sure it would be more expensive, and it may actually not be technically feasible, but I have not reviewed that.
Anything else from the board for staff before we open up our hearing? Thank you so much. Appreciate it. Yeah. At this time, we'll welcome the applicant and their representative, and we'll swear in first. Yes.
We have a number of standing
Mhm.
applications. We probably, before they testify, we'd like to get through the standing applications.
Okay, let's do that. And we have an order of submission, Griffin?
Yes, so the first one we received was from Gina Maselli.
Ms. Maselli, so this is not your opportunity to present evidence. What we are trying to determine is whether you have standing and the ability to participate in this hearing sort of as a party. So what the board will be asking you is to present information as to why, what is your injury, should this variance be granted, and how that injury is particular to you and your situation as opposed to the community in general.
Okay.
Thank you.
So
Hold
my-
on.
And we'll start with Griffin,
I'll
yeah?
swear you in, so please raise your right hand and state your name.
My name is Gina Maselli.
Do you swear or affirm to tell the truth and nothing but the truth?
I do swear to
Thank
tell
you.
the truth and nothing but the truth.
Welcome, Gene. Thanks for being here.
Thank you. And thank you for having me. As I said, my name is Gina Maselli, and I live at 1419 Old Fort Road, which is directly across the street from the property that this variance would be on. And there is a stream, the stream that is involved in this variance flows from that property onto my property and through my property into Echo Lake.
Okay. And how will your property be impacted by this particular project as proposed?
So the area of Old Fort Road that we live on, from 1200 to 1600 is a very unique area geographically. We receive 3 times more rain than the surrounding areas. So if we get an inch forecasted, we get 3 inches of rain, and so on and so on. And during Hurricane Helene, that became even more evident of what the dangers of that situation being, because we had significant landslides in the area, which caused the death of 15 of our neighbors. And all of this, many of the slopes failing and coming down. And, excuse me, this is a little hard to talk about. Less than 1% of the population of Buncombe County lives in this area that I'm speaking about, the 2-mile radius area. And as I said, we had 15 deaths, which is 40% of the deaths in Buncombe County. And the danger that this would pose to us is that it should be evident that the amount of stormwater that this area receives in a storm event like that can be potentially catastrophic even without disturbances. And should a disturbance take place, it increases the danger exponentially. I think that's all I need.
I'm looking for the monetary damages or hardship. You know, what to you personally will this, and how are you unique than any other of your neighbors?
Okay, so from erosion that has already occurred from the lot, from work that has already taken place, we've had a significant amount of sediment already in our yard, which is shown in images in my application. We had someone come to quote the amount of removal, and it's been about, the quote was around $20,000 for the removal of the amount of sediment that has come into our lot from storms, and especially from Hurricane Helene, the amount of sediment that came down.
You describe the topography of your lot as it meets this property line and their lot as well. What's happening?
Okay, so their lot is up a very steep slope. The mountains rise around Echo Lake sort of in a cove shape. And they are one of the steepest slopes up behind Echo Lake. And so our lot is right on Echo Lake. Theirs is across the street on Old Fort Road and up higher. So the stream comes down very steeply down their lot. The slope rises about 1,000 feet very quickly behind us. And the stream comes down very quickly and it then enters our lot, which is a more level lot. And the stream, normally you can about step over it. It's less than a foot wide. but during Helene, it was about 50 feet wide with the amount of water that came down from that area. And the area in our yard that is now a giant sand silt area it's between our yard and our neighbor's yard, and it's over 50 feet wide, the amount of sand and rock that came down during the storm.
We're looking on the map, one of the maps provided at an access road that this driveway would come off of, or the logging road currently comes off of. Do you share that road in any way? Is that a private?
I do not. I'm on the other side of Old Fort Road.
Well,
One thing I'm a little confused by, and in this particular situation, I almost wish we could have heard from the applicant first before I asked this question, but I'm looking at the application, and in the answer to the question about unnecessary hardship, it seems to say that the road is already graded. And my interpretation of this, and if somebody knows differently, I'd love to hear it, is that the only thing they're asking for is to be able to use the road, because the road's already there. At least that's what I see from the answer to this question. So, assuming that's correct, assuming that the road is already graded and all the applicant wants is to be able to use the road, what hardship do you have that would start when they start using a road that's already there?
Well, the amount of work that's already taken place on it has already caused a lot of erosion issues onto our lot, and the work is not done. The amount of work they would have to do to make the road usable is not done. The road as it is right now is not usable. There's a great amount of, like I said, the erosion that occurred from Helene, and there was a lot of work that was done that we have records of complaints we had to put into soil and erosion because the soil fences were not put up correctly and they were not maintained, and they still have not been maintained. Since Helene, they are completely flattened, and there's no silt fences or anything like that up in place, stopping the silt coming down. So the amount of work that has happened in a fairly negligent manner, and the amount of damage that's happened because of it has been significant. And there will still, as you can see in the plan, there's more work that will have to be done to make this a usable road, and that amount of work is what we're concerned about.
here's where I am. Can you speak to, on this buffer, on this property line, if there were a failure of that particular new driveway that's proposed, can you speak to what would happen on your lot and the impacts to your property?
Absolutely, I'd love to speak on that. So as I said, our lot is downhill and downstream. Were that mountainside to fail, it would destroy my house, and it would kill me and my family instantly. And it wouldn't just go into the valley, like the Craigtown landslides that happened before, they continued for miles and miles. And this would be different because those landslides did not meet a body of water. This landslide would instantly, one of the first things it would hit would be Echo Lake. And in hitting Echo Lake, it would be like throwing a bowling ball into a bathtub. Echo Lake is a bit shaped like a bathtub in that it's got high mountains around 3 of its edges, and then it has the dam where it sort of opens up, the valley opens up. And were the landslide to enter into the lake, that water would go up the steep slopes, and then it would all come back down in the lake and over the dam, and you'd have hundreds of thousands, if not millions of gallons of water going down Cane Creek all at once. You think about in Helene, we had that much water going down, but it was over a day at a time, that amount of water. And as it was in Helene, it still took out several houses and caused deaths downstream of us. But if you had that amount of water, if the dam failed from the lake, I mean, the deaths would be
Help
in the
me
hundreds.
understand where you live along Echo Lake, because I got a picture of it in front of me, and so, where on Echo Lake are you?
I've got some more pictures here. So the Stern lot is outlined in blue here, and then my lot is directly below it right here on this part of Echo Lake. Does that make sense?
Like here?
So essentially, my lot is in between the Stern lot and Echo Lake, and I'm right on the lake.
You're south of Old Fort Road.
Yes.
And the stream that flows into your property, headwaters are not on the applicant's property, they're further up. So the water that flows down that stream is not specific to the applicant's property.
No, it's
Multiple.
specific to Mr. Wilkie's property, who is he can also speak to the fact that there are other right-of-ways that are an option here as well. So,
Mr. Chair, can I ask if it's possible that we've drifted into testimony?
We're teetering on the line, but we're responding to board member questions that are getting more specific because we're trying to just ascertain what the claim is for standing. So, yeah, I think we've heard two or three different elements of that. So, I think I'm okay if y'all are okay to. Need a motion? Yeah, we do need a motion.
If I could just ask a couple of questions. I represent the
Please.
applicant, Brian Golden, attorney here in Asheville. I represent Mr. Stern. He's here to my right. If I could just ask a couple of
Please,
questions of Ms. Maselli. Ms. Maselli, your property is not immediately adjacent to Mr. Stern's, is it?
no, it is not.
And in fact, a large 12-acre tract owned by Mr. Wilkie separates Mr. Stern's property from your property south of Old Fort Road.
It does. The stream continues through his property and then onto mine.
And what's your education, training, and background in?
Design.
All right. And so do you know anything about engineering or landslides?
No, but I've witnessed catastrophic landslides immediately adjacent to my home and seen the death of 15 of my neighbors.
Do you have any expertise in appraising the value of anyone's property?
No, I do not.
Do you have an expert who's going to come and testify about the possibility of landslides or the depreciation in the fair market value of your property?
No, I do not.
You indicated on your standing application that you thought you would suffer special damages, but you checked a box, if I'm looking at it correctly, that says the damages I will suffer are not distinct from those damages to the public at large. Is that still your testimony?
My understanding of that is that the damages I would suffer would be the dangers incurred by this, the potentials of this lot would be the same to mine as they would be to everyone downstream of us on Cane Creek. So I would have the most damage because I'm immediately right underneath it, but there would be others as well as myself who could possibly be hurt by this.
And so with no expertise in being able to determine what land will slide, when it will slide, after what event, who is going to testify to what you're talking about here, the possibility of landslides?
I'm here to testify for myself.
Do you have any expertise in that area?
I do not specifically.
Okay. You talked about already sedimentation coming down that roadway. Did you go up that road to determine where the origin of that sedimentation was
Yes,
from?
I did.
And where was it coming from?
It was coming from the work that was done without the correct silt fences installed as they were still down. They were not maintained. And you can see as you go up there, Mr. Wilkie has additional photos of it when he comes up to testify that the sediment's coming from there.
Do you know you talked about easements. Do you know what easements are on Mr. Wilkie's property to allow access to Mr. Stern's property?
That's not my area to speak to. Mr. Wilkie can speak to that.
Did you not look to determine, because you testified to this board that you thought there were other areas, other easement areas that allowed
Oh, yes,
access to
yeah.
my client's property. Did you do any investigation to
I
make
did.
that
I spoke
statement?
to Mr. Wilkie, and he showed me the areas that were also an option.
Okay, so you spoke to Mr. Wilkie. Are you aware of Mr. Wilkie as a real estate attorney here that has the ability to interpret where easement areas are?
It's his property, and he's able to speak to that.
Okay. We would just ask that she be denied standing. She's testified, and we're happy to hear what she has to say about her generalized fears of landslides, but without expert testimony as to when it will happen, where it will happen, how it will start, and any devaluation in her property, all of what she's talking about is A, speculative at best, and generalized fears. Nothing directly related to special damages which are distinct from the rest of the community. In fact, she said any damage, if any, would be the same as everybody else in her community. So she's failed under the Mangum test, Cherry v. Wisner test, that says you have to have specific credible allegations of special damages which amount to the diminution in value or the loss of enjoyment of your property related to the secondary effects of the proposed action, the application. We're asking for a variance to allow the installation of a road. And you'll hear more about it. But I don't think she has enough. She hasn't said enough.
That's
to-
not correct, sir. I did say how mine would be worse than most of anyone
Party
else.
to speak at one time.
Sorry.
Each party at
Yep,
one time.
and so I don't think she has stated enough to satisfy the Supreme Court, North Carolina Supreme Court case, Mangum versus City of Raleigh, that talked about what it takes to have standing.
Thank you for that. Appreciate it.
Thank you.
And follow-up question here. I have some notes here from our back and forth a minute ago with the board, and I have a note down here that this property that you own is adjacent to the proposed property. That is not correct, is that right?
No, that's not correct.
Adjacent. You're downhill, but you've got at least one property of 12 acres, if not others, between you.
Yes, yes, sir, yes, sir.
Okay, thank you. Other board questions? We'll give you an opportunity to do a closing remarks here. Anything else from the board? Good?
I have a question.
Yes.
Tell me again why you think you would have more of an impact than your neighbors would.
Well, the flow of the land, if it were to fail, would come through my property. It would go into the lake, and then the water, we do need a hydrologist to speak to the issues of that, but common sense would dictate that it would be catastrophic if a landslide were to enter a lake and the water that would go everywhere else.
So you would say that,
And the waterway runs through our property. The waterway that is involved in this variance runs through our property, so.
okay,
Okay, we're done.
all set.
I'm ready to close.
Any other follow-ups, Carol? You have anything else, Carol? Okay. Anything else? Okay, all set.
One more
Oh,
question.
sorry, please.
Are there any other property owners that have this stream flowing through their property where it meets the lake?
I'm the only property owner that the stream meets. Oh, the Duckets, yes, the Duckets are on the other side of the stream,
At the lake frontage.
at the
The
lake frontage, absolutely.
So you are not unique. There are two.
There are 2 homes, yes, that could be impacted by this, yes.
Okay.
Can we close it?
I think we can finish up, yes. You have any closing remarks before we deliberate?
Um,
Anything
on-
to summarize?
Just in summary, I would ask you all to consider the dangerous implications of this variance and also look at all the facts of other options that Mr. Wilkie will speak to about other ways that this property could be accessed.
And if anyone comes for standing today and they aren't approved, of course, we would invite you at the end of the hearing to stay around and give your comments as a witness, of course. So,
Okay.
thoughts, comments?
My thoughts are, I think she'll be fine as a witness. I do not hear anything unique that would cause her to be in standing.
I would agree with that.
So I make a motion that she just be a witness.
Okay. Motion to deny standing. Is there a second? You got a second over there?
Okay, so yeah, officially, a motion to deny standing.
Okay. I hear a motion and a second. All those in favor say aye.
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 Any opposed, nay?
Nay.
Okay, thank you. That motion passes. Thank you. We invite you to stick around and be a witness in the case if you'd like to. Moving to our next applicant for standing.
William Wilkie. Please raise your right hand and state your name.
William Wilkie, Jr.
Do you swear or affirm to tell the truth and nothing but the truth?
I do,
Thank you.
Can you speak up a little, because I'm having a hard time hearing you.
sure.
Welcome.
Is that better?
It is. Welcome, sir. We appreciate you being here. Can you kind of give us an overview and go over why you think you might have standing in today's case, rather than go into detail on the matter, or if you'd prefer to withdraw that and speak as a witness today?
Well, I do own property, I guess on 3 sides of the Stern property. The easement that, where the road was cut in without permit, I would say, comes across my property. It has caused nothing that I can prove, because Helene did hit, but there's no doubt that additional water has come down that cut that was not properly graded. Sill fences were not installed, drainage was not installed properly.
Well,
That-
I'll just object to testifying. I'm
We're not
happy to
gonna,
let him
we're not
as a
gonna take,
witness.
we're not gonna take objections during the standing protocol. We're gonna go back and forth. Yes, sir.
Could you repeat the question?
Yeah, sure. Oh, sorry, it was my question. Sorry.
Yeah. Could you repeat your
Will you just give
question?
us a brief overview of why you believe you might have standing in the case as a party to participate in the hearing?
Yeah, I feel like the use of that easement was done improperly. It has caused significant erosion. Immediately beside it into a trout feeding stream. And it has, downhill of that, it has also gotten into another trout feeding stream, actually all the same one. And all of those are on my property.
Help me understand what three sides of the property are you on?
To the north, the south, and the east.
North, south, and east. Okay.
Have you incurred any financial loss as a result of, let's say, Helene and the water that originated from this logging road?
You know, it's impossible to quantify what came down that logging road. I've been told that the damage downstream of that is in excess of $50,000. I've attempted to get help from agencies that apparently is not going to happen. I do own heavy equipment myself, and I'm probably going to try to do some of it myself, but I'm going to end up paying at least, no question, $30,000. The driveway downhill of this used to be the footprint of the driveway, the drivable surface was, I'm going to say it was about 14 to 15 feet wide. It's now down to 8. A car being about 6 feet wide. That gives me 1 foot into a rock bank or 1 foot to a vertical drop-off. My driveway now is highly dangerous. Mr. Stern has made it clear he's not going to pay a penny on any of that. I think it would be, it's a reasonable assumption, and I think it should be obvious to a lot of people that the stormwater that has come down that easement road, that again, was conducted without grading permits and without sill fencing up, has caused a tremendous amount of water to come down that would not otherwise have been there.
Is your residence on the northern lot or above the hill from this property?
It is.
It is, okay, thank you.
One question I have, it's been stated today that one of the requirements to get standing is that you demonstrate a potential loss that's different from anyone else's. Could you summarize how your potential loss is different from or more than anyone else's loss?
Well, I think I just did, didn't I?
I'd like to interject something here. The actual wording is the damages will be distinct from the damages of the public at large, not necessarily anyone else, the public at large.
Well, his neighbors.
That would include neighbors also, but yeah. Can you speak to that, how your property individually is more impacted than than most other people? Public at large.
Well, I think the fact that, I mean, all this water has come onto my property, it has eroded my stream banks. I mean, the $50,000 is just to make my road safe to travel. It has come across, I need a drawing.
We've got the map just in front of us, so if you want to describe it, there's another one there.
Okay, where this originates at the, I'm gonna call it the southeast corner of the map, it looks like that is, yeah. That's where the darker driveway, the new driveway is shown, is in the darker color, correct? Is everybody with me
The
on
new
that?
driveway.
You agree?
Yeah.
Okay. That easement begins there and runs 2/3 of the way up to a turn that makes a looks like about a 135-degree turn. That water on that far eastern section where the new road is cut, there's a stream that runs right there. A lot of mud has fallen right there in that stream that is solely on my property. It came down through that to where the origin, at the origin point of that driveway, it came through there, came across there, and cut out about a 15-foot square section of the road that could not have been from anything but that. It came straight down that road and took out a huge section of the road there that I was able to fix myself because I do have heavy equipment. It took me 2 weeks. How do I put a price on that as far as what my damages are? If I charged by the hour what I normally make during the day, it would be tens of thousands of dollars. That stream, I mean, the silt fencing that should have been in place along that stream in that first section, it should have been there, it was not there to prevent water going down in there. There's that, I mean, that creek is full of trees and debris. What can I prove happened from this? Maybe not a lot, but if anyone looked at it, you could draw a logical conclusion that, yeah, a lot of that did happen because this road was there.
And sir, you would say that you are the only neighboring property owner that uses this road, that shares this road with the applicant uphill from the property, correct?
Uphill. That's,
And
well-
if something were to happen to, that's correct?
right there.
No one else uses the driveway besides you?
Headed north from that
Headed north, yeah.
intersection.
And that if something
I'm the
happened
only
to,
one at the moment.
right, and if something happened to the road below you, below your home and the lots you own around it, that you wouldn't have a way out, correct? There's no other way out from your property to the main road?
That's right.
Okay, thank you. Anything else from the board? Yes.
To applicant's attorney
Okay,
standing, yep, and then.
Oh, I was
Yeah,
just
go ahead.
looking at him using his finger to draw, and I forgot to sit down.
Do you have anything for Cross?
Yeah,
Or not Cross, but,
yeah, no,
That's-
just some
yeah.
questions.
yeah,
Thank
some
you.
questions, thank you.
Mr. Wilkie, you're correct. The easement on which this road was built, through the example that we were just looking at, that easement goes across your property, correct?
Yes.
And that's a deeded easement. It's referenced in your deed as well as Mr. Stern's deed. Do you recall that in your deeds?
I do.
Yeah. And so are you saying that you don't want Mr. Stern to use that easement that is in your deed reserved to him?
I never told him that. No, that's not what I said. I think it should have been done properly. He hired a guy to do it that, in my opinion, had no clue what he was doing. It was put in improperly. It was not permitted. It would never have been approved to have been put in the way it's put in if it had been done. But he hired somebody that did it in the dark of night.
And so you're not here having an issue with the variance. You understand that his road has to go in that easement area?
No, I don't understand that.
Okay. You're not here complaining about the easement, you're here complaining about the work that's already been done.
I'm complaining about the work that has been done and the damage that he has sustained of his own making. I mean, this is a problem of his making.
And
He's the one that caused all this by not doing it properly, by not getting the permitting done. And he did have another way in, and I resent the fact that the statements that the neighbor would not grant him any alternative route. There were 2 additional routes that were offered.
So you didn't grant, you're the neighbor he's talking about,
Yes,
and you didn't grant him the access across the stream, did you? To cross the stream? Nevertheless, strike that. You're not a hydrologist, are you?
no,
You can't talk about landslides and hydrology and what will happen when it will happen as it relates to landslides.
no,
And your property, strike that, your roadway access in and Mr. Stern's roadway access in shares a driveway all the way up till they split on your property.
correct.
And you're talking about Hurricane Helene, damage sustained on your road, that you're just going up there and saying it's obvious, but you don't have any expert that's gonna testify as to what caused the damage, do you?
The damage began occurring
have
before
any-
Helene hit.
Do you have any,
No, I do not have an expert.
those would be my questions. It's unfortunate, again, I understand he's a surrounding property owner, we'll have all the exhibits that are necessary for this board to understand where the easement is, where the property lines are, which will make it easier. But again, no specialized damages distinct from the rest of the community, which amounts to a loss in the property value. And so we would just say, he probably can be a witness if he wants to come up and say anything more than he already has, but I don't think that he has offered enough testimony, credible allegations for standing.
Thank you for that. Anything else to close out, to summarize? And you'll have time, obviously, to get into detail about things later on if you're granted standing, but this is just for the standing piece of it.
I want to make it clear that this was not the only option he had. This was his choice to use that. There was another option that a grading contractor told him would be
With
better.
respect, the board can't really hear testimony about,
Okay.
about your objections to the project. It's just about whether you have standing to sit here and be a part of the hearing. So, yeah, if there's nothing else, we'll go ahead and proceed to board deliberation.
I do not think he has enough for standing, but I invite him to be a witness.
I believe he does
I
have
think he
enough for
does have
standing.
enough for standing,
I agree. He's unique.
because
He's the property
is-
owner with the easement.
Yeah,
He's the one that shares the road, the drive and the road. And he's going to be the most, if not the pinnacle of damage.
But the easement's there, it's been there, and he's actively using it, so I don't see any difference. Because what he's asking for is to build off the easement to the rest, and so he's not,
But again, he has standing. The question is whether he has
whether he
standing.
has standing,
And
not
he is
whether the
unique.
project is correct.
The creek is on his property, runs through his property. He's adjacent to the property on 3 different sides. He's unique.
If something happened to the road below him due to the applicant's project, he wouldn't be able to get out.
Can I make
He's
one
the
more
only
statement?
one using it.
Right.
So we've closed that part of it, I'm sorry, yeah.
No, I'm in full agreement.
Yeah, I
with-
think, so there's no question in
Begging
my
and-
mind, he has standing, yeah. Any other thoughts? Okay, is there a motion?
Motion to-
Mr. Chairman,
No.
based upon the evidence presented to this board, I
No,
move.
no.
Yeah. On standing.
Motion to accept him
Yeah.
for standing.
Yes.
Motion to approve standing.
Well, yeah, go ahead. If it's the standing one, yeah, go ahead.
Yeah.
Please, yeah.
I move that the board approve the request to participate in the hearing as a party with standing for the petitioner, Mr. Wilkie, based on the petitioner having demonstrated that he meets one of the following legal standards: that he has an ownership interest, that he will suffer special damages as a result of the proposed action, that the damages that he will suffer are distinct from the damages to the public at large.
There has been a motion, is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay?
Nay.
That motion does appears to pass. Thank you so much. We'll call you up after we're done with the standing applications and be a part of the hearing. Thank you. Next standing application.
Why did you say that was
We thought it was the,
Wanda Melton?
sorry, go ahead.
Wanda Melton, okay. Naomi Lee? William Melton? Okay. Thomas Maselli?
Thank you, sir.
Please raise your right hand and state your name.
Thomas Alexander Maselli?
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
Welcome, sir. Thanks for being here.
Thank you.
If you want to kind of summarize why you're here and, of course, what grounds you might have for standing in this case.
Okay. I also live at 1419 Old Fort Road, which is directly downstream of the property in question. The waterway, for which this variance is being deliberated, runs through my property. If I may continue. We have continued to see, but during Hurricane Helene, I've got photographs before and after. We have imagery of a before and after that storm event, showing what that waterway normally looks like, and then the material deposited on our property. So photographs of that, and also even as of rain events as of May 5th, we're still seeing continued contaminated water flowing through that stream and into Echo Lake. My concern, being a proximity of our home to the waterway that is being affected by this variance, is could even be loss of life, basically. But even so, we already have debris flow from that streamway on our property. I've also got some documentation showing that the logging road in question, which once again affects this waterway, and in turn affects our property because it is upstream, and material flow going into that waterway goes downstream and across our property. I've got some documentation from the Planning and Development Department that this excavation, the roadway in question, was done without permit, and has actually been multiple times in notice of violation of the Sediment Pollution Control Act. So we have some documentation from Buncombe County per records request that this wasn't an existing roadway. This excavation was done without permit. And I've gone up, per Mr. Wilkie, I've gone up on the driveway, but I've not crossed onto this person's property, Mr. Stern. But from what I can, there's visible signs of erosion from excavation there.
And can you speak to how, if any, your property is unique from the general public's property around you?
Yes, so once again, the general public versus one other property owner, so.
Neighbors, yeah.
I want to make sure that that is clarified from when Gina was speaking. But my property has the waterway running through it that is downstream from this variance request, and material flow that may result from basically not complying with the basically the Sediment Pollution Control Act, Soil Erosion, Sediment Control Ordinances, basically the findings from Buncombe County on this could result in more damage to my property. These ordinances are here for a reason, and they were found non-compliant. So my concern once again is sediment depositing on my land. In the event of a major storm, another major storm, the potential for a larger debris flow to potentially destroy a house and kill my family and myself.
Anything from Mr. Goulden as far as questions?
Not to belabor the point, it's the same, your wife's Gina, correct?
Yes, sir.
And so you're reiterating what she had said.
No, sir. I am stating what I've just stated. I'm not reiterating everything that she said.
And you-
Also, I believe there was sorry if you're questioning.
Yeah, I have a
Also,
question.
yeah,
listening.
I believe that you guys came, the board had a clarification after discussing whether or not Gina had standing, that it's not just, are you the only person affected by this, but are you affected by this uniquely from the general public? I don't believe that, it sounded like from there, that that was not the way that that was considered.
You in fact checked the box that you will not suffer damages distinct from those to the public at large. Do you remember checking that on your application?
Please show me, sir.
Are you Thomas Alexander Maselli?
Yes, sir.
Is this the application that you filled out for this variance request?
Being that you're presenting to me, I can't say whether it is or not, but I'd like you to,
Are you at 1419 Old Fort Road, Fairview, North Carolina?
yes, sir.
Telephone number 828-231-5903.
Yes, sir.
ThomasMaselli@gmail.com.
Would you like me to review the document, and then I can tell you if it's the document I submitted?
Do you recall submitting this document wherein you check the damages I will suffer are not distinct from those damages to the public at large?
I recall checking, if you,
In the document and let him look at it. It's probably a little bit easier than you stand, so
Yeah.
let him review it and then ask
why
him.
are you
some-
only handing me one page, sir? That's not the entire document, is it? Oh, it does say, I will suffer specific damages as a result of the proposed action that is subject to this hearing specifically. So
Flip the
I-
page over.
I believe that I do see that checked, sir.
Flip the page over.
Okay.
Would you check on the backside? If you can read that.
This says that I will not, okay, so this is saying the damage I will suffer are not distinct, because they may impact the entire community. So my interpretation, if this is the document, unadulterated that I submitted, was that I would suffer both distinct damages because of the waterway running through my property, proximity of our home site to that waterway, and the debris flow coming across, that we've already seen on our waterway. I will suffer distinct damages from that. My interpretation of this statement, the damages I will suffer are not distinct from those to the public at large, are unique, they impact the entire community specifically. So was that there could also be damages that impact our entire community as a result of this variance being approved. So I believe that
your
I
assertion-
suffer specific damages, but there also could be an impact to our community at large, being that the material flow goes into Echo Lake. If the dam were to fail from a debris flow, it could impact those downstream. So that was my interpretation. Here you are, sir.
Thank you.
Do you, and
Sorry, let's finish with Mr. Golden's statements if he's got questions.
Well, and we would just make the same arguments. You haven't testified, are you a hydrologist?
No, sir.
You have any expertise in dam and
Would-
dam breaching and dam failure?
No, sir, which is why I believe everything I've said so far is based off of observation.
And everything is a potential, again, no more questions. What I would say is, after Ms. Morsani asks her question, for the same reasons, his wife doesn't have standing, we would say he hasn't shown special damages separate and distinct from the rest of the community.
so my question is, do you and your wife live in the same residence, same location, or are you in separate locations?
We are in the same residence, in the same location, and once again, one of the reasons that I'm still coming up in your speaking is, I believe you potentially dismissed her as having unique standing because we have a neighbor that also has a stream crossing their property. Was that a question that you asked specifically?
That wasn't a
You
question.
don't have to
So
answer.
my question was, are you two in the same household?
Yeah, no,
And then that's in
but the
my question.
reasoning for,
We're going to give you an opportunity to summarize.
Yeah,
after
thank
the
you.
board asks their questions. Just focus on the board questions, if you will, at the time.
yeah, so, yes,
You've answered-
I am
you've answered
in
that
the same
question.
household, absolutely.
We've heard an answer to that question. Thank you.
Yeah.
Carol?
My question is to the attorney, is it a requirement for standing, or else to our board, to our attorney, is it a requirement for standing that someone has a particular expertise in evaluating property?
It doesn't. In order for standing, there has to be an injury to fact. It's an invasion of an illegally protected interest that is A, concrete and particularized, and B, actual or imminent rather than conjectural or hypothetical. The injury is fairly traceable to the challenged action of the applicant, and it is likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision regarding the variance.
Thank you.
But yes, if your question is specifically, does he have to be an engineer?
Yes,
Not for the standing part, no.
thank you.
Joel?
Yeah, you had mentioned there was excavation done without a permit.
Yes, sir.
You have documentation that?
Yes, sir. I
Okay.
obtained that via Public
Okay,
Records
who
request.
did the excavation?
Joel, I'm sorry to interrupt. I'm sorry about this, but we need to focus on the standing pieces of that, and
Okay.
that's testimony. Yeah, sorry. Strike that. Anything else?
So,
How many property owners does the stream flow through?
all I can speak to is, that I'm aware of is Mr. Wilkie's properties and my property and the Duckett's property. The stream is roughly along the boundary as it enters Old Fort Lake, sorry, not Old Fort, Echo Lake, my apologies. It is roughly the boundary between our two properties. And I do have photography, aerial imagery from Buncombe County GIS showing the stream before and after the storm event,
Right.
showing that it does have, that stream has deposited material onto our property.
Thank you.
Yes, sir.
Any other board questions? Hearing none. Any closing statements about standing only?
Yeah, once again, I just want to make sure that I have the correct understanding that for having standing, it's not necessarily that it was the general population at large. I know that seemed to be something, I'm sorry, what was your name again, sir?
Mr. or Brian, you can come.
Brian, yeah, seemed to be something he was questioning me on, so, was that, yes, relative to the population at large, being that the waterway passes through my property, that there's debris flow onto my property, and that the documentation I've obtained shows that the property upstream was non-compliant with Buncombe County ordinances. And there's, once again, only one other, I believe only one other property owner upstream, Mr. Wilkie. And we have that non-compliant property. Visually, I've seen erosion without trespassing. I've seen erosion from their excavation, and it's reason to believe that these events have caused damage to my property, me personally, and could in the future.
Thank you for that. Just to answer, so everybody's on the same page, I think that the answer to the first part of your closing there was just that the general public language is correct, but it's mostly interpreted by the board case to case.
Yes.
As in the neighborhood or surrounding community. If you have 100 neighbors, 100 lots, what makes your particular property unique from all your other neighbors? And that's the general application of how we do that. Now, to say that maybe 3 total property owners or 4 total property owners along this stream bed or this debris flow pathway could be impacted, the board has to kind of make a call there on whether one individual, one property owner might have standing there, or all those four. I mean, that could be true also, but the board has to draw a line somewhere. So that's what we do up here. So that's kind of the answer.
Understood. Hopefully I've
So
answered that.
you're clear, yeah. We have finished with that. Is there a motion or a comment from the board?
I've got a question for
I
Kurt.
have a question too.
Let's go right here first, Craig.
Kurt, the two applicants for standing, husband and wife, live in the same house, own the same property. What if this board came to different answers on question of standing?
Well, I think the issue would be is based on each individual witness and what evidence they presented at their testimony. If the husband happened to present different evidence than the wife did, I think it's possible that you could get differing results if there was additional information that was not presented by the testimony. Because remember, your decisions have to be based on the testimony of the witness. So if a witness doesn't, say something and another one does, you could get a different outcome of that.
Thank you.
Yeah, Carol?
My feeling is that he filled out the application incorrectly, but that he does have damages that are different from the damages to the public at large. I think we improperly denied standing to his wife, and I would like to see us grant standing to him.
Okay. I think that he is just like his wife. He's not unique and special. I think he should be a good witness, but I do not think he should be granted standing.
Mr. Chair, this isn't
It's
in discussion yet, right? This is,
We're in discussion right now, yeah.
we are, okay.
You finish your comment, though?
Yeah, no, and it's something that Kurt said, what was, read that, considering standing there, just, yeah, please pull it up again and just read through that. Because there was something in, like specifically that Kurt said that, he falls in. I'm sorry, Kurt, I put you on the spot.
Was that one window?
Happens when you shut that one window down,
know,
then
I'm
they
sorry.
immediately ask you the question about that. So, once again, it's an invasion of a protected interest that's concrete and particularized,
Yeah.
and that's actual or imminent. The injury is fairly traceable to the challenged action of the applicant, and it is likely, as opposed to being merely speculative, that the injury would be redressed by a favorable outcome. So hence, the potential injury to the standing applicant, if the variance was denied, would somehow be a cure for that,
Yeah.
for that injury.
So I think it's all conjecture. I don't think there's concrete and, for his standing, but I think he's better as a witness.
Okay. Other comments from board members?
I think he should have standing.
Okay.
I think the public at large is the people who live much farther away. There are two families that are impacted by this, and I think both of those families should have standing. I think they meet all of the qualifications.
Other comments from the board?
I find this as a challenging, but 30 minutes ago, I was in one particular position, but based upon how you answered the question on the original form, that provides me with additional understanding, and I tend to agree that this gentleman does warrant standing. There are only 3 people that are on this waterway.
I'm aware of, sir, yeah.
3 unique people. We're not talking about the lake, we're talking about the stream. And he doesn't have to be an expert, but any of us who own land, if you have that mudslide on your property, I think there's going to be financial damage to the real estate value of your property. Now, do we need to have an expert for that? All of that would be testimony, but back to the question of, would he have standing? Yes, he has standing, in my opinion.
But the mudslide was from Helene, a completely separate
No.
issue.
Well, we're talking about potential mudslide.
It's the potential, just the potential
failure
risk.
Due to the road, to the driveway coming up, or
Yeah.
anything. Something happened due
If
to
somebody
this
was building a
project.
retaining wall and
Yeah.
it would collapse, all the potentiality
Yeah.
that this could potentially hit this gentleman and his property.
One general question, or I'm not sure if this is a question or a comment, but we've had a lot of discussion about things that happened in the past. Like what happened from Helene. And
It's not, yeah.
it's always been my understanding that we're only talking about what would happen in the future if we,
Correct.
right? So,
The board has to sift through that.
Okay, so what happened in the lien has nothing to do with
Correct.
this?
Correct.
Exactly. Yeah, so Helene has nothing to do, we can't look back, we can't say,
We're looking
because
forward.
of Helene, that's what's gonna happen in the future. And so you have to disregard the Helene pictures.
Yeah. Anything, Joel?
Yeah, the only thing that, I guess I'm concerned with, that he provided was something about excavation that was not permitted. And the question is, did that contribute to the problem affecting his property?
I think we're
That's
gonna
my
get, as far as the permit goes, or non-permit rather, I think we're gonna get there in the hearing. But I think we'll get to the issue of whether work was done on the property without a permit in the hearing. But as far as his standing piece of it, that's what we're kind of focusing on now. Mhm. Anything, Jeff?
Yeah, I think he does comply with getting standing. I don't know that he's gonna have, enough of a cup full of stuff to prove any damages. That's down the line, but given that there's only 3 parcels, we don't have a public at large situation.
Yeah, I was going to mention this later. It's a very good point. I was going to mention this later on before we started the actual testimony here. But obviously, each member with standing has an obligation to present the board with relevant expert testimony on items that require expert testimony. Anything else would be lay opinion, et cetera. And board has a responsibility to weigh expert opinion much more heavily than they would a lay opinion. So that's just a general note to everybody. Great thoughts. Thank you. Any motion?
I make a motion to deny standing.
There's a motion
Second.
to deny standing, and there is a second on that motion. All those in favor, please say aye.
Aye.
Any opposed, nay? Nay. I believe that's a 4-2 vote. Is that correct? That's what I heard.
Hold
1,
on.
2, 3, 4, 5.
How about can we do
How
a
about we
show of
raise hands?
All right,
hands?
let's raise hands then,
Those
okay.
in favor,
You want to go each person for the staff? Okay. Let's do a voice vote by person. Start with Mr. Mazells. Aye.
Aye.
Nay.
Nay.
Aye.
Nay.
Nay.
Staff, what'd you get?
that the motion failed.
Motion failed. Okay. Is there an affirmative motion?
Motion to accept. Well,
There's a motion to accept in a second. All those in favor, please say aye. Aye.
aye.
Any opposed, nay?
Nay.
1, 2. Right?
You're a nay.
2. No, he's an aye.
Said aye.
Did he say aye?
He's
Hold on,
not.
why don't we do the votes thing again? This is the motion to grant standing.
Grant standing, yeah.
So Joel,
Aye.
Nay.
Aye.
Aye.
Nay.
Aye.
Aye.
Okay, I did miscount. That's right, it's 3 nays. Yeah.
Okay.
Okay, thank you. Yeah.
thank you.
So that motion passes. Thank you
So
very much.
you are granted.
You granted standing, yeah. We'll call you back up when we start the hearing and finish the standing applications. And have we finished, or is there the list? Okay. We finished the list of those who applied for standing ahead of time. Is anybody else in the audience today wishing to assert standing in this case? Going twice, going 3 times? Okay, thank you. We are. Let's do that now, I think, before we start things.
Okay, and I will have a brief discussion with the people granting standing so that they understand some parameters as to what we'll be dealing with.
Wonderful.
Okay.
Take a 10-minute break. Thank you. we will come back to order at this time, and we will. Okay. You'll be separate parties with standing, of course, but you'll be at the same table, of course. And everybody has been sworn today, except for Mr., yeah, that's right.
But, and everybody, please make sure that you speak into the microphone. Okay, so if you're standing at the dais, speak into that. Brian, make sure that you're using your microphone. And Mr. Maselli and Mr. Wilkie, make sure that you all are using your microphone. Okay, thank you.
Okay, we'll open up the hearing at this time and ask Mr. Goulden to present.
Thank you. Just briefly, I'm going to call Mr. Stern, the applicant, to the stand, who has not been sworn in.
Thank you.
Yes. Oh, yep.
Please raise your right hand and state your name.
Alan Stern.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome.
Mr. Stern, just briefly, well, where do you currently reside?
My permanent residence right now is in Houston.
All right. And do you own property here in Buncombe County?
Yes, I do.
Is that property the subject of this variance request?
Yes.
All right. Did you submit an application for a variance?
Yes.
And what was if you can, just tell the board, what were the general requests that you made and why you made them?
The requests for the variance were made because the existing right-of-way I have to my property is too close to a stream, and the only way I can access the property is by that right-of-way. In order to get the access to the property, I need the variance.
So I'm going to show you what I'm going to project on the screen, and I'll identify it as just applicant's Exhibit 1. Do you see that up there?
Yes.
You see that? Can you identify that for the board?
That is
Once you
the
put your glasses on.
plat map of Dove's Landing.
All right, and I'm going to, this property identified as parcel number 2, is that your parcel?
Yes, it is.
All right, and if you can describe for the board, as you're seeing it on the screen, and I'll try to outline it, where your access is, starting from the cul-de-sac.
Sure. Well, from the cul-de-sac, it runs in a sort of northwestern, yes, as you're showing on the screen right there. It runs, that is part of the right-of-way that accesses my property. It makes a switchback right there, comes back along this easement, this right-of-way, which is Mr. Wilkie's property, to this point of intersection between my...
Included with the application are this exact same property. I don't have to introduce it, he can testify to it.
I'm
But
just trying to make sure that it wasn't in the previous packet of things that have already previously been admitted.
It was.
Looks to be a different map,
It was
though.
not.
Okay.
It was not.
And I've got extra copies if we,
Well,
Yeah, let's proceed to admit that as a
well,
exhibit.
hold on, show a copy to Mr. Maselli and.
Can we hold on to this guy?
oh yeah, absolutely, 100%.
So, do you all, if you look at that, do you all have any objections to that being admitted onto the record?
No objections.
No objections.
Okay, thanks.
Thank you.
Thank you very much.
So that, the Exhibit 1, does that fairly and accurately depict a plat of your property?
Yes, it certainly does.
And all of the other properties that are surrounding it, do you know who owns those?
Yes, they're owned by Mr. Wilkie.
So that one, this one,
That one.
that one, and this one, are those all owned by Mr. Wilkie?
Yes.
Do you know how long that right-of-way has been in existence?
Yeah, the right-of-way existed when I bought the property. In fact, it existed long before I bought the property. It's existed since 1981.
And have you gone back in and looked at additional plats from 1981 which show the location of that?
Yeah, yes, I've seen plats that show it previous to that.
And I'm going to show you what I can mark as applicant's Exhibit 2. Is this what you're talking about?
Yes, sir.
All right, and is this the area in which we were talking about your access to the road?
Yes, it is. If you look at the lower half of that, yes.
Okay, and this little switchback that's right here, is that hard switchback that we identified on Exhibit 1?
Yes.
All right, and do you know, if we pull that out, can you see when that was recorded?
Certainly, that was recorded, obviously, right there in 1980.
So at least from your investigation, that right-of-way to access your property has been in existence since 1980.
Yes.
All right. It's been re-subdivided and recombined since then, but since 1980, that roadway and that easement have been in existence.
Correct.
If I show you, do you recognize this plat also?
Sure, that looks like the same road, yes.
All right, does this one show does that one show your road your easement as it currently exists and the easement of Mr. Wilkie's?
Yes, it does.
And if you can describe what's in front of you for the board, where is the stream that we are talking about?
If you see the two roads in the
Yep.
two roads which are in the northeast corner of that area, the stream runs between those two roads.
Does the stream, and I'm going to show you something,
Yes.
but does the stream run right along
That
in there?
That's what I was trying to describe, yeah, with words, but poorly.
Okay, and I'm going to show you what's in the application. Now, this has been submitted as part of your application. Does this identify a better location, or does it describe where the stream is?
Yes, I can see the stream there, yes, it's shown, yes.
Is it right there?
Yes, that's where it is, yes.
And does the green, now this is in the application, does the green, what does that depict that's on this slide that we're presenting?
The green area on the slide there shows the right-of-way
All right,
and the access to my property.
all right.
Do you have copies of that? Because I don't remember the original application. Slide you showing.
Yeah, that's with the original application. I thought you all would have copies of that.
It's under maps, I think, right?
Yeah, I think it's under full plan set.
Full plan set, okay.
Mr. Stern, did you create that right-of-way?
Of course not, no.
All right.
That was existing, like we already said, long before I owned the property.
And when did you first buy that property?
That was bought in 2010, I believe.
And have you reviewed your deed, and do you know the access that you're granted to your property?
Oh, I've looked at it many times, yes, I understand it.
All right, and I'm going to show you what is your deed, and does this grant you, that's a little blurry, does this provision grant you access?
Yes, sir.
All right, and when you're reading this provision, Where is the only access that's granted to your property?
The right-of-way, which crosses lot number 3, is the only access to my property.
And who owns lot number 3?
Mr. Wilkie.
All right. Do you have any alternatives? We'll go back to, do you have any alternatives as to where you can gain access to this property that we have here?
If you look at where the road is and where the right-of-way is, and you look at the topography of the lot, one might say you could access it from that lower southeast corner.
Are you talking
but the-
about in here?
Yes, but the topography prevents any chance of doing that.
And did you look at alternate locations on which to gain access to your property?
Other than the right-of-way, yes, I did,
All
yes.
right. And tell the board what you did, looking at other alternate options to gain access to your property.
Sure. If you look up into the very northeast corner of the property where the switchback is, yes, there is a common lot line between, I think it's lot 3 and the one that's to the north of it, I don't know the number, where a potential access could have been a 90-degree cross of the stream bed directly into the where the first switchback is.
And if I can just show this, does this better describe, does this
Yes.
more accurately reflect what you're talking about?
Yes, if you see the black line with the arrow pointing into it on the very
Northern part
the
of
northern
this?
part of it, which says new easement and culvert, that was investigated as a alternate entry point to the route, now, to my lot. That,
That's just, he's just testifying to it.
Yes, it's in our application. It's in the
Yeah, it's in
application
the
packet
application.
online. If you have a device with you.
I don't see it on, it's not in our packet.
That's
So-
not in the packet?
Nope.
Okay.
I don't see it.
Let's retrace our steps then on this document, Mr. Golden.
I'm sorry?
Do you, yeah, he asked me to retrace. Do you know what this document is, or do you know what this exhibit shows?
Yes,
And-
what would you like?
What does this, did you create this exhibit?
Yes, I created that diagram.
Was this diagram part of your looking at alternate accesses to your property outside of the deeded easement?
Yes, as you can see, I highlighted here in red the existing access road, which is the old logging road, and the black line across this, which the arrow points to new easement and culvert, that was investigated as an alternate route, which would completely avoid the right-of-way which parallels the stream bank. That lot, that new easement would need to be agreed to by Mr. Wilkie.
Mr. Golden, before the next question, can you clarify whether this document we're looking at on the screen has been admitted?
It has not been admitted. It's just, he's just testifying to alternate locations, accesses, and we're using that as demonstrative to elicit his testimony and demonstrate his testimony.
Do we need to admit this, Kurt?
Well, I don't think you can admit anything unless somebody asks for it to be admitted. So they so far have not asked anything to be admitted except for Exhibit 1. And I believe there have been 2 other maps that have been shown that have not been admitted, although the
I did not
witnesses.
see that. I thought that was included in our original packet. This one I haven't seen though, with the illustrations on it.
You know, once again, I'm trying to make sure that we're clear on what's already been admitted in the original packet and what hasn't.
Me too, yeah.
So is this part of the record?
No, the testimony is, but the actual document has not been admitted at this point in time. So no, it is not on the record at this point in time.
And Mr. Euler is correct. The testimony is, this is just going to demonstrate his testimony about other alternate accesses that he attempted to investigate.
Is it possible, Mr. Golden, to use a map we already have admitted to do that?
Sure, yes, yeah.
And maybe a pointer or something like that?
Yeah.
Is that possible?
Yep, yes, it is. Thank you. And this, again, Mr. Stern, it's been admitted, or it's part of the application. You see the document that's in front of you?
Yes.
All right. And so on this document, to illustrate your testimony, this document, if I may, shows a road on one side of the
Stream?
stream that, and we'll just point to that real quick. Who utilizes that road?
Mr. Wilkie?
All right, and so then this is the narrow section right there of your road.
Right there is the switchback, and yes.
And then when you were talking about utilizing an alternate access, if I may, does your alternate access that you just testified to, is it approximately in this location?
Exactly.
All right. And was that possible for whatever reason?
It looks very feasible to me. It looked very feasible to my engineer, Mr. Edsel.
But were you able to do that?
I was not able to do that. I requested that from Mr. Wilkie. Mr. Wilkie denied my request.
You would have to get permission to cross Mr. Wilkie's property outside of your easement in order to do that.
Yes.
All right, and you spoke to Mr. Wilkie about that?
Yes, by email, yes.
All right, and what did he reply to you when you asked him about that?
He told me no.
Okay. Now, when you are looking at access, this again is part of the application that's been submitted. There's been some conversations about the road that's been constructed. Tell the board what happened with the road being constructed without a permit.
Sure. Being very new to Asheville, being new to home construction and road construction of any type, I contacted a contractor to help me develop access to my building site. He told me at that time that I did not need a permit, and being as naive as I was at that point in time, I believed him. So I okayed the work to be done, and that was about a year and a half ago, roughly. And the road was constructed, and except I should point out that the right-of-way easement, which was an old logging road, existed again since the 1980s. That was regraded and improved a little bit, but that part was not substantially changed from where it was.
Did you perform any of the work on the roadway prior to getting a permit? Did you do any of the work yourself?
The work was not done by myself, no.
All right. Were you here in Asheville overseeing any of that work?
I was not.
Did you investigate, so you talked about other areas that you investigated. Did you investigate this southern, southeastern area down here for access?
Absolutely. I looked at that 100 different ways, and I discussed it with engineers. The topography is just impossible. There is no way that any access could be obtained from that southeast corner because of the steepness of the grade.
And as part of the application that's been submitted, you recognize this document?
Yes, that is the plan put together by the engineer.
And you understand that what you're really asking for is a variance to encroach within a 30-foot buffer to that stream.
Yes, sir.
If the variance isn't, and we'll highlight where those areas are. Do you recognize these two areas as being the areas of where you're requesting your variance?
Yes.
All right, and they're pointed to with the black arrows?
Right, the black arrows show that.
All right, and so those areas of your roadway within inside of your easement are too close to the stream bank, and you need a variance to encroach into the stream bank.
Yes, that's correct.
If the variance isn't granted, what's going to be the natural result?
The natural result is that I will not be able to develop, the lot will be undevelopable. There will be no access to the lot without traveling over that right away.
All right, and so I want to just go back real quick. We did, and Mr. Euler so correctly indicated to me, we have shown the board this map, you remember, or this plat, you remember seeing that?
Yes.
right there. And then, so we'll identify that as plaintiff's exhibit, or applicant's exhibit 2.
Do you know what the plat book reference is?
Yeah, 46-182. Yep.
Mr. Golden, that plat book, that's unaltered. You've made no changes from what you pulled from the public record?
That is correct. Pulled
Okay.
from the public record, unaltered, deed book 48, page 182. Didn't alter the date that it was filed or who the surveyor was, nor the location of the road.
I just want to, I get it. I'm just trying to make sure that it's an exact copy of what's on the public
Okay,
record.
yes.
So thank you. So, Ms. Maselli and Mr. Wilkie, did I get that right?
Yes, sir.
Okay, so basically, do you all have any objections to that document? It's actually a copy of what's in the public record in the plat book at that
So-
deed book and page
So
number.
what is the roadway drawn in there referencing, just so I'm clear?
That's showing the easement.
Okay. And where is that in reference to the existing roadway that Mr. Wilkie shares with the property owner?
You can, it's the exact.
This is what we share right here.
Okay.
I think the question is whether you all have an objection to that being in.
Yeah, I'm just,
No.
I'm making sure
Okay.
whether I want to. Yeah, no objection.
Mr. Wilkie?
No objection.
Okay.
And then I've got the one other one.
Thank you.
What's that? Did he hand it to you?
Thank you.
Yeah.
Or he hasn't given it to us? That's exhibit 2, right?
Yeah, that's exhibit 2. You want
Okay.
to watch here. And then, Mr. Stern, you testified to a third one. And I'll represent to the court that this is recorded at Plat Book 46, page 195. In light of Mr. Euler's questions, this has been unaltered, and we would mark this as applicant's Exhibit 3. Mr. Stern, do you recognize this exhibit?
Yes, I certainly do.
All right, and again, is this the exhibit that you earlier testified to, showing again the location of the right-of-way and the separation of the right-of-way, or strike that, the easement from yours and Mr. Wilkie's?
Sure, it does. You see the two roads. One of them is my easement. One of them is the road which goes up the mountain along the stream bed to the higher, to the properties above.
All right, and then again, I think you testified that this one may have been recorded in 1981. Oh, let me
Yes.
turn that for you, I'm sorry.
Yes.
Did you share a copy of that plat yet with the?
Nope, I'm getting ready to right now.
Okay, thank you.
And that's deed book 46, page 195, unaltered direct copy. I printed it on
Turned
the
around
right.
now. Okay, this is Old Fort Road. And that looks so much different. Okay, I think it's the same.
Yeah, the note right there, what they did. Where's the other name?
Was this all one piece of, one parcel up here at
Okay,
that
so
time?
this, you're showing this joint right here is there? No?
It's,
That joint's changed, these two plats are different,
Okay,
but this easement remained the same.
okay.
that is, this is where that sprouts off right there.
Yeah.
What's that?
That right there, is that
So,
right there?
wow, everything's changed.
Where's your dance?
This
You did a mini tile search.
This says
You did a mini tile.
11.11, which is .11 right there, jumps up. So it went all the way down here at that point.
Okay.
So, Mr. Maselli and Mr. Wilkie, the same questions. Do you object to exhibit number 3 being entered on the record?
It's an old document I've never seen, but I understand.
It's being represented that it's in a plat book. It's on the public
No
record
I have
section.
no doubt about it.
Okay.
Thank you. A question?
So again, it's your testimony that at least since 1980, your current roadway, which accesses your property,
Yes,
it has been in existence since 1980, and your property is basically right in there.
which is about 45 years, yeah.
Okay. Now, you had talked about the hardship. If you aren't able to receive the variance, what's going to be the natural consequences of that?
The lot will be undevelopable because there will be no access to it.
And did you do anything to create the lot lines, the location of the easement, the access to your property?
No, sir, no.
And you understand that you're looking at, so you're looking at the hardship, the not being able to develop your property. Is it your testimony to the board that you didn't create any of those hardships?
Yes, I did not create any hardships.
Did you just buy that piece of property?
Yes, I did. I bought the property with the existing rights-of-way, assuming that it would be something I could retire to and build a retirement home on.
And when you're looking at the alternative accesses that you talked about, you investigated those alternative accesses. What made those impractical or impossible?
Yes, I looked at them extensively and thoroughly. The southeastern access is just way too steep of a grade to put any kind of road in. And the other access, which would have avoided the right-of-way, which we discussed, would have required a new easement or right-of-way, I don't know what the correct term is, across Mr. Wilkie's properties, and that was declined, denied, or whatever you want to say, by Mr. Wilkie.
All right, and so when you're looking at the 4 factors that the board considers, can you testify to the board what the unnecessary hardship is that would result from strict application of the ordinance, which means setting your road back 30 feet from the creek?
That would put me outside of the existing right-of-way, outside of the easement, and into a section of the hillside, which would be very difficult to develop without extreme retaining walls.
And could you even put your road outside of the easement?
It would require dynamite and I think and everything else.
It's on Mr. Wilkie's property, isn't it? Your
Yes,
easement.
yes.
Yep, and so describe for the board the peculiarity of this property that results in this hardship that you're talking about.
I'm sorry, what? Can you-
Describe the peculiarity of your property. And I think you've already testified a little bit to it. The topographical impossibility.
Yes. Right. If you look at the topography again of the lot, the only reasonable access is the one that is currently on the plat map, which is the right-of-way near the stream, which does the hard switchback and then enters my property.
And when you're talking about that extremely difficult, we've already looked at this map, you're talking about in this area.
That area, yeah, there is a ravine there, which you would need like mountain climbing gear to go up and down that hill.
Does that topography make it impractical to try to engineer a road up to your home site?
Yes, it does, sir.
All right. Those would be my questions of Mr. Stern.
Mr. Wilkie, do you have any questions?
Sure.
Please speak into the microphone.
Use the microphone.
Mr. Stern, did you ever look into the cost of building that bridge that you were talking about?
No, because you told me I could not do it.
Okay, so it could cost $150,000 for all you know. Is that a fair statement?
I think that's ridiculous, but I did not look into it.
Okay. Do you recall meeting with a grading contractor by the name of Keith Florence?
I have met him, yes.
Did you also meet with a contractor named David Mounts, who was partnering with Keith Florence
No,
for grading?
no, sir.
You didn't meet with him? Okay. Do you recall my offering to you another right-of-way that you have not mentioned today?
No, I do not recall anything.
You do not recall that immediately as you entered the property from Old Fort Road, being able to come up anywhere there to the left of the existing road to cut in, which would have been less of an overall climb to your house site and also would have been a southern exposure the entire way. You do not recall any of that conversation?
No, I don't think that ever occurred.
So you think I only gave you one option, and that was from the junction there in the curve where there was a ravine and you didn't feel like that, you felt like that was far too steep? You think that was the only option that I offered you?
I don't recall you offering me that option, no. But that option exists, but I don't remember you offering that to me.
Okay.
That one you're talking about is the one that's very steep, correct?
I'm sorry?
That one you're just referring to just now is the one that's extremely steep, correct?
It could be. It didn't have to be if you're familiar with grading, but that was not, in my opinion, the better of the two
I'll just object
options
to
that I did
his,
offer you.
I'll just
Hold on,
object
Mr.
his-
Wilkie, please make sure that you're asking, this is not a dialogue. You
I'm
need to
sorry.
ask Mr. Stern questions. He will respond to your questions, but you are not to be testifying. And I'm not saying that as that, but just make sure you're asking questions of the witness and the witness will respond to your questions.
So just to be clear, you do not recall having a conversation with me or with any other grading contractor, excuse me, about an offering of another right-of-way to you that ran along the, let's just call it for the sake of ease, the western side of my property that comes in, and that would tie into directly to the south side of your property. You don't have any recollection of that whatsoever?
No, could you show me that on the plat map? I don't know what you're talking about. The answer is no to your question.
Okay.
If we could keep a map up, that would be helpful, though.
Yeah, which one? I'm happy to put up whatever one we
The
need.
topo would be great, actually.
Yeah. So I think I've got a topo up with the outline of his property.
Okay.
This one would be great.
That one? Okay. You tell me which one you want, and I will put it up.
That one with a topo would be good, but just this one right here would be good. That's the overall showing
yep.
the 6 different lots in that
I got you.
development.
Okay.
That one right there?
Yes.
Okay. And I don't mind if you want to come up here and point out, but as long as we can explain, if you want to ask your question, if you need to show Mr. Stern where you're talking about, I'm happy to let you come up there and point it out to him so I can see it.
I'm talking about anywhere in here.
Okay.
To gain access.
Could you highlight that, Brian?
Yep. Yes, thank you. I will.
Actually, was anything to the left of the road, any of that property in there was offered to get in here.
So he's talking
That
about,
area right in there, what I offered you, well, I'm sorry.
Well,
Th-
yeah,
This
his-
is the area I'm talking about, right in there.
And so, Mr. Wilkie, if you will come here, if you point to me and you can show what you think you offered, just show, and I'll put it up there.
The existing driveway, this is the existing driveway,
Yeah.
and these are the lot lines. This is my southern, I'm calling,
So from right here, where did you,
I offered, well,
Hold on,
I'm
hold
hold
yeah.
on. You all are almost having a side conversation.
that's correct.
from the-
Yeah.
from the
If-
board.
Right.
So can you,
I was trying to draw for them to show.
I get it. I want the board to be able to see what the question's about, but Mr. Wilkie, please ask the question
Okay.
of the witness.
Sorry.
No, I'm just trying to make sure that they,
I think we're on the same page trying to identify that, but I think it's more appropriate during your presentation, Mr. Wilkie, is where their offering was, if I'm not mistaken. But you haven't answered that question, of course.
I think he asked you, do you recall him offering that?
No. Mr. Wilkie, did you put that into an email
Well,
or
let
any?
him- We'll just
Yeah,
let
any,
him answer.
any further questions, Mr. Wilkie?
Any questions? Yeah.
Yeah.
Okay.
I don't have any other questions.
Thank you, sir. And Mr. Maselli?
Yes, sir.
Yeah. Questions?
speak in the microphone too, Mr. Maselli. No, that's all right. Thank you.
It's tough to remember, yeah.
Yes, Mr. Stern, I believe you made some statements that, hopefully I'm not paraphrasing, the topography prevents access to that. The topography is just impossible in reference to potential alternate right-of-ways and access to your property. Is that correct?
Potential rights of way and access, yes, that's
Okay.
correct.
Do you have any documentation from any experts on where you investigated those alternate routes?
I would have to ask my engineer, White Edsel, if I ever brought that up with him, but I don't. If, I might have, I don't remember.
Okay, yeah, and so are you an expert on roadway excavation?
No, sir.
Okay, just making sure. So the responses you gave to your attorney in this hearing then are more your opinion then? Is that correct?
Objection, he didn't offer them in form of opinion, improper question.
Can you rephrase that?
So that was not expert testimony, correct?
No.
Okay, and you, are you able to provide documentation then that shows your investigation of alternate routes?
I'm sure I discussed it with many people, including, I believe I discussed it with Wyatt, when we were looking for other routes into the property, and there was nothing viable.
So I know Mr. Wilkie has at least stated that he's offered you an additional route that's not been maybe shown as one of the ones that you said were non-viable. My
According to
question
him, he
I'm
did.
sorry, sir, I'm still asking a question. My question to you would be, if a alternate route was offered and it is a viable route, would you accept that as opposed to this variance?
Objection, that's a completely impossible question, calls for speculation. There has been no alternate route testified to that's been offered, so it's an improper question.
I think part of it is relevant, though. Can we rephrase the question? We'll sustain that. And can we rephrase the question, leaving out part of it? All that's all I can give you.
Yeah, which part do you
That's all I can
specifically
give
object
you.
to?
The part that's objectionable.
Thanks.
Regarding other routes, though, I mean,
Yeah, it basically, I myself am not an expert on roadway excavation, so I can't discuss, I can't speak to whether additional routes that have been offered are viable, but it sounds like a alternate route has been offered or is being offered currently.
I'm
Sir,
just gonna
can I- may
object.
I want to
finish
get
my
the full
question, please?
question out. Yeah, more quick.
Yeah. So an alternate route is being offered. Mr. Stern, correct me if I'm wrong, but my assumption would be if you were not aware of this route previously, you've not investigated this route, correct?
Object to, I'm just going to object to the form for Mr. Stern having to assume that Mr. Maselli is wrong. I just think that
I'm
that's.
gonna allow it. We'll overrule that. Allow
Okay.
it.
Repeat your question, please.
Yeah, absolutely. So, once again, you have stated in response to Mr. Wilkie that you're not aware of an alternate route that was offered to you, correct?
Yes.
So the alternate route that was offered or is being offered, you have not investigated that route, correct?
How can I answer that when I don't know what the alternate route is, if there was one?
Would you, yeah, I believe that Mr. Wilkie during this hearing was drawing it up on the screen, correct?
Valid question, valid answer, yeah, on the last one.
No, once again, you all are not presenting evidence. There is no evidence Mr. Wilkie has not presented any evidence to the board, so anything that you are referring to should be either in the packet that was submitted and posted online, or one of the exhibits that Mr. Goulden, if you were referring to, but you're kind of asking him to testify to something that's not on the record at this
Yeah.
point in time.
I'm trying to, determine.
Tell them they'll have an opportunity.
Yeah,
You
if
will
I have an
have an
opportunity, I'll ask
opportunity to
during that
present
time.
your
Okay.
evidence at a later time, but
Okay.
right now you're focused on asking
Yeah.
questions about Mr. Stern's testimony.
Yeah, and it's just understood. If I have an opportunity later, then it'll be more appropriate. Thank you. So regarding the excavation of the roadway that you're currently looking for a variance for, so when was that roadway excavated, roughly?
That was about 18 months to 2 years ago.
Okay.
I don't remember the exact
And
timeframe.
did you
Prior
contract?
to Helene, for sure.
Oh, thank you. Did you contract that labor?
Yes.
Okay. So would that be, I guess, the excavation on your property that you contracted? Would you say that you're responsible for that work?
Yes.
Okay, thanks. Are you aware that did you receive any notices of violation?
Yes.
Okay. How many did you receive?
There's only one violation.
Okay, so you're not aware of a follow-up visit and make sure I phrase this correctly, a notice of continuing violation?
Yes, that's for the one violation, yes.
Oh, okay. Okay, so you're aware of the violation, initial violation, and then you're aware that there was a notice of continuing violation?
Of course, because when
Okay.
the initial violation, notice of violation came, that notification said, cease all work. At that point, all work was ceased, and nothing has been done since.
Is that all that notice says, is cease all work, or does it have any stipulations about mitigating the property in any way? Any erosion control?
When it said cease all work was ceased.
Okay,
That includes all work, everything.
okay. And it doesn't say anything, or does it say anything about mitigating any of the work that was done?
I don't recall the term, the verbiage.
Okay. Just last question for clarity. I genuinely don't know this, but you mentioned that you purchased this property in a hope to build a retirement home on it, correct?
Right.
Okay. So is that still your intention?
Yes.
Okay, so you have you reached out to any real estate agents or anything in the past 3 years?
What's
Objection
that
not-
got to do with anything?
Yeah, objection
okay,
not relevant.
Okay,
I'd say
understood.
it's irrelevant, yeah. Any other questions? No.
Just a
Redirect-
couple of.
Redirect.
Redirect, yeah, if I can get my screen back up. Again, just so that we're clear, when you are testifying, as it stands right now, you've got the roadway down here that touches a portion of your property which allows access.
Yep.
And did you investigate the possibility of accessing your home site via that location on the southeast side of your property?
Yes.
All right, and what did you discover during that investigation?
It was impossible.
The only other access that you have is via this, or,
Objection. He's stating that that's the only other access.
so
Let's let him finish the question. We'll see if it's relevant.
where is the only other access to your property?
The existing right-of-way.
Okay, and if I'm gonna mark it right here, does my red marker indicate your existing right-of-way?
Yes, that is the deeded right-of-way.
And is that the area in which the work was done?
Yes.
And when you were issued a stop work order, did you stop all the work?
Yes.
And as far as you know, you've got no other deeded access or no other portion of your property touches any roadway?
No.
All right, those would be all my follow-up questions.
To open up board questions for Mr. Stern, I'd like to have, if Mr. Golden would assist Mr. Stern in going through these Exhibit 2 and 3 to describe in more detail to the board. We heard some questioning back and forth, but we have yet to hear what these are indicating for us. So we know the right-of-way, of course, but maybe the history of division as well on these.
Yeah. Mr. Ball, you're talking about this one?
Yeah, 76, 140, I'm sorry, 46, 195, and 46, 182.
Okay. So, Mr. Stern, the question's been asked, what's the difference between these two documents? You see it up there on your screen?
No.
Oh,
Okay, that one? Mm-hmm.
yep. And so when you're looking at it, what does this access off of Old Fort Road show?
That shows the existing roadway that accesses all the lots in Dove's Landing.
All right. And notwithstanding that it doesn't have all the subdivided lots, does it fairly and accurately depict Dove's Landing where your property is located?
In terms of my property, yes. I can't say what's north of that, yeah.
All right. And so when I expand on this, can you describe for the board what that little sharp intersection is?
Yeah, that's the right-of-way. I mean, that's the switchback.
That would go ultimately to your property?
That would ultimately lead up to the property, yes.
All right.
The
And so-
cul-de-sac.
So that early one in 1980 that you've already testified to looks a little different, and we'll try to put it in the same,
You rotate it?
yep.
Okay.
We'll put
Yep.
it in the
Mhm.
same,
And that's the way it looks today.
and that's the way, and is that the little sharp corner that you're talking about, the switchback?
Yes.
And the cul-de-sac, that's all on your property?
The cul-de-sac is, strictly speaking, shared between Mr. Wilkie's property and mine.
All right, and you testified that the stream runs approximately right down through the middle of those roads?
Yes, sir, yes.
All right, and is that shown, again, for clarification purposes, is that shown on the exhibits which we've all been looking at?
Yes, the stream is shown there.
Okay, And when we're talking about the stream being shown between the two roadways, again, in green is your right-of-way, is that correct?
Correct?
And then going eastward on this document is that right there, what's that?
That is the stream bed.
All right. And what's that right there?
That is the gravel road which goes up the mountain to the northern properties.
All right.
Okay,
and
so
then-
I hate to interrupt, Mr. Golden. Let me rephrase the question. That we're looking at the topo map right now on
Yep.
the screen. We have these two documents that were passed around, Exhibit 2 and 3. I wonder if you can take us through time when these documents were filed and talk about where the lot is, where it originated from, because we've got two different documents here. We're not sure how they relate to present-day lot
And also-
size. So,
One has Old Fort on the right, and one has Old Fort on the left. They're kind of confusing.
yeah, kind of orient us on what we're doing here.
Okay. You see that right there?
Yeah.
All right. So up here in the top is a north arrow. You see that right there? I just highlighted that.
Yes.
Right. So that's a north arrow. So everything will orient to the north based on the north arrow. Is this plat a plat of your property along with Mr. Wilkie's property?
Yes.
All right, and so I'm going to expand. This is your property as it exists, Lot 2, in 2025,
Yes, that's correct.
all right? And your access is off of Old Fort Road, right, down here on the southern portion of the property. I'll highlight that.
Yeah, that Old Fort Road cuts through the lower right corner of the map there.
Right, and then you take a right or a left up onto your, up into your, I guess, Dove's Landing.
It does land, yes.
Right, and Dove's Landing is the subdivision in which you own property,
Yes.
all right? And as you go north along here, come around here, right here, the roadways split. Is that correct?
Yes, that's where it splits, yes.
All right, and then you go up here to get access to your property,
That's all correct, yes.
all right? And so as it relates to that, the access and your switchback and access to your property will go back to I think it was exhibit number 2. And we will align with the north arrow. All right, so you see the north arrow here.
Yep.
So we're looking at north. If we expand upon here, does this fairly and accurately still represent the approximate location of your road which accesses your property?
Yeah, I think the north arrow is a little different on this map than it was on the other map, but yes, the Old Fort Road is still in the same place it was, and the access roads, the roads into Dove's Landing are still where they are.
And now your parcel, if I've highlighted there, would that fairly and accurately represent the location of your current parcel as it exists in 2025?
That's pretty close.
All right. And then if we go to Exhibit 3, right? So we have got, again, we've oriented it with the north arrow, somewhat going north, basically straight up the page. And so if we highlight it, is this Old Fort Road and your access into Dove's Landing?
Yeah, it still looks the same to me.
And as you go north along that road into your property, I think you testified earlier, there is a difference now in this area.
What do you mean by difference?
Well, it looks like that the access to Mr. Wilkie's property is a little further south than it was in the previous exhibit.
Okay, yeah.
All right, and so if we look at that, is this area right here, is that still your switchback?
Yeah, that's the switchback, yeah.
And, whoops. Oops, sorry, guys. And if we were to highlight your approximate location of your property on this map, is it again approximately right here?
Yeah, that's pretty close, yeah. It might go a little bit further south, but that's pretty close.
All right. And so as it stands now today, the only access you have into your property is across Mr. Wilkie's property as shown on these 3 plats.
Yes.
And 2 of the plats are historical back in 1980s, but from your knowledge, has your entryway, has your roadway into your property, which is highlighted here in yellow, has that changed at all since the 1980s?
Not at all.
Thank you, that was very helpful. Yeah,
Did that answer your question, Mr. Ball? Okay.
yeah, thank you.
I have a
Board
question.
Questions? Yes, Carol?
I have a question where the attorney highlighted it. It didn't look like it came down far enough.
Yeah, you're correct.
Because it looks to me like this road crosses his property down in the southeast corner as well.
Right, so it would be,
Yeah, it would, the yellow would go, yeah, right about there, maybe. That's very close. That's very, very close.
and we can look at, and I apologize, I can't be accurate, and again, my
You're forced to use
kindergarten
a,
technology.
you're forced to use a square where it's not really square.
Yeah,
It was re-subdivided. It was, the line was changed.
yeah.
So, yeah.
So this is what this is what it currently looks like. Or is this currently what it looks like now?
Yes.
And the area, again, the north arrow is a little different oriented, but I've been highlighting basically this area on the other plats.
Right.
Okay. Other questions?
I have a question. Why couldn't you access your property from that southeast corner?
The topography is so steep that you literally could not climb that without ropes and tackle, and I don't know what else you'd need. It is, the chances of putting a road in there are zero. I mean,
Could you speak
if it would
more
have been
into the
possible, I
microphone?
would have loved to do that.
Did you get a professional explanation about why you could not access your property from that spot?
I would need to defer to Mr. Edsel.
Yeah, we have an engineer that's coming up next.
Yeah, the engineer will be a much better person to answer that kind of question.
Okay. But so for the record, you did have a conversation with Mr. Edsel about that access?
I recall, I think, I'll have to say, I think so. I think I did, but it would have been about a year ago, and my memory's not 100% perfect.
Other questions? Please.
Now, you mentioned the variances granted, it would encroach along the stream bank.
That's what I understand.
Yeah. Did you bring a hydrologist or an expert to testify what impacts that may have?
A hydrologist? No, sir.
Pardon?
No.
Okay.
Other questions?
I could speculate, but it wouldn't be worth very much.
I have one last question.
Please.
Okay, just to repeat or clarify, you don't recall meeting, discussing the options that Mr. Welke brought up?
That is correct. If he brought them up, I do not recall. I don't, to my knowledge, there's no record of that. If Bill Wilkie says he did, I'm not calling him, untruthful, but I don't recall that.
Well, then, the option he brought up, would you be willing to entertain that now?
Well,
That's a very different question. I mean, I don't know if we have time to get into that kind of thing here.
I would just object to that question because if he says it hasn't been offered, and it hasn't been offered, there's no access along that southern boundary. That's all just speculative. We're looking at really this plan, where his access is, and what he's asking for is the variance. But there's been no written, right? And the statute of frauds would say that any kind of transfer of interest in real property has to be in writing, signed by the party bound thereto, and Mr. Wilkie didn't say that he's made that offer and signed it. So,
I think part of that question, Joel, if I can help interpret that and sort of rephrase, a question might be, Mr. Stern, would you be open to another access granted by Mr. Wilkie from his property? So as not to have a conflict with the stream buffer here.
I would take it into consideration, sure, of course.
Other questions from the board? Okay, seeing none, we'll, we're not, no, we typically don't do, second.
Normally, just what happens is Mr. Goulden asks direct, then you have your cross-examine, and then based on the questions you ask on your cross-examine, Mr. Goulden has the opportunity to redirect his witness, and then it ends. No, well, you would need to ask the board permission to recross.
Yeah, I think we'll probably forego that unless the board feels strongly elsewhere.
Can we also?
But you do have your presentation to give next, you know, you have testimony to give.
Okay,
you know,
and we can provide evidence at that point.
all that. Mhm. Yep. Any more board questions? Last call. Good for, okay. We're all set then. Thank you, sir. Appreciate you.
Thank you.
we'd call Wyatt Etzel, unless the board needs to take a break. It's 2:44.
We're good. We can power through.
Perfect. Mr. Etzel, if you'll come to the stand. Can you state your name and profession for the board?
Wyatt Edsel, licensed professional engineer.
All right, please raise your right hand and state your name.
Wyatt Edsel,
And do you swear or affirm to tell the truth and nothing but the truth?
yes.
Thank you.
All right, state your name again and your profession.
Wyatt Edsel, licensed professional engineer.
All right, talk about your education and training to become a licensed engineer.
I have a four-year degree from NC State University in civil engineering and specialization in water resources. And I have 12 years of experience practicing engineering in this area.
And do you hold a professional engineering certification?
Yes,
And are you current on all of your continuing education to maintain that professional engineering certification?
yes.
How long have you been a professional engineer?
Seven years, plus or minus one.
And in your capacity as a professional engineer, do you often assist clients, individuals with designing, whether it's roads, home sites, or otherwise utilizing your skills?
Yes, that's the majority of my workload.
All right, do you do land planning and other work in that field?
Yes,
All right, and were you asked to do that by Mr. Stern?
yes.
All right, we would just ask that Mr. Etzel be qualified as an engineer, land planning, and you said what else?
What specifically is it, in terms of an engineer? I mean,
Yeah, I said land planning, and I forgot, Kirk. So land planning, and you testified water resources.
Yeah, I would say that my field of expertise is grading, drainage, erosion control, and stormwater.
We would ask that he be qualified as a professional engineer in those areas he just testified to.
We don't
Yeah,
have we don't have a CV, Kurt. I wonder whether,
Yeah,
whether
Mike,
we should.
may I ask or object?
well, you can.
Yeah, objection, I'd just like to ask, so do you have any certification regarding, I guess, any kind of water resources? Or
I'm a licensed professional engineer.
okay, is there any certification required in terms of dealing with like trout waters or waterways?
Typically, a professional engineering license can do those things.
So you believe that you have, okay, you believe that you have a
He's answered the
qualification?
question.
Yeah,
Okay.
he says, yeah.
Question.
Before we do, I'm sorry, we can just qualify him as an engineer. I mean, period. Covers everything.
Well,
Maybe
it depends what
qualified
he's giving his
specialties.
expert
I'm an
opinion
engineer,
on.
but that doesn't help, I mean.
Right, like, you know, like you, just because you're an engineer, do you have the specific, you know, I guess it depends on what the specific questions are. That's what I'm trying to get at.
Agree.
You know, because engineer is a little broad.
But but as a licensed professional engineer, he's qualified in those to do those things. He doesn't require another licensure.
I believe that he's an engineer and he says that he has some, yeah, I mean, but that's ultimately, that's a decision that the board needs to make.
Okay,
or
let's
you as
ask,
a-
if we do have a copy of his CV or anything else to back that up right now.
We do not have a copy. Do we have a copy of your CV? Do you have one online that you can pull up?
My engineering license?
Yeah.
Yeah, it's public record on the North Carolina Board of Engineers and Surveyors website.
And as far as your education and training, and I'll go in and ask you a little bit more about that. Tell the board a little bit about your work history for the past 12 years after you graduated with your engineering degree.
Sure, yeah, I graduated NC State in 2012 and started work in this area, Buncombe County, in 2013. I worked for Altamont Environmental, Anchor QEA, and Brooks Engineering Associates, and I did grading, drainage, erosion control, and land planning for subdivisions, commercial development, residential development, institutional, and other types of projects in that period of time.
And about how many projects would you say that you assisted in grading, drainage, erosion control?
Last year, I did 80 projects, and I would say that 60 to 70% of them were in that field.
All right, and you talked about storm water management. What's entailed with stormwater management as it relates to projects?
So when you disturb over an acre in Buncombe County, you're required to get erosion control and stormwater permit, and this project was required to have those permits, and I did the engineering for them. The stormwater is required to provide post-development runoff rate match for the 1-year, 24-hour storm and provide non-erosive design of channels and pipe outlets in the 25-year storm.
And how long have you been dealing with or designing land planning with a concentration in erosion control and stormwater?
Since 2013.
All right. And about how many plans related to erosion control and stormwater have you designed? This year, if you know.
This year I have around 50 projects, and last year I did 80.
All right. And do you seal each one of those with your professional engineering certification?
Yes, my seal is on everything that I do.
All right. And does that then, I guess, what's the benefit of having your seal on your plans that you designed?
It's a minimum requirement for acceptance for review by Buncombe County.
All right. And have you submitted all of these 50 plans? Has any of them ever been rejected?
They receive comments that must be addressed before they're approved.
And do you address those comments? Do you have expertise in addressing those comments?
Yes.
All right. Again, we would offer, based upon that additional testimony, for a professional engineer with experience in grading, surveying, waterway, stormwater, and erosion control.
Not surveying.
Oh, sorry.
Thank you.
Grading, waterway, stormwater, and erosion control.
Thank you. I think that was helpful. Joel?
But do you have any documentation as to your work experience, education? Because that's come up before the board again. Many times.
Joel-
for expert
Joel-
witnesses, there's documentation,
Joel.
so.
He answered a minute ago that question that they don't have a CV.
They
with
don't
that.
have a CV, but I think that you can take notice that his engineering certificate or his license is a matter of public record.
Yeah,
on
I
the-
actually looked it up and found it. And I
So,
can
yeah,
see
you
it's
you
current.
could, you
We
can
have
take
to
notice
consider
of
the
that.
testimony at the hearing only on this, so.
In addition, the fact that my license is current demonstrates that I have a 4-year degree in the field of engineering, and I have 4 years of experience that was vouched for by 5 licensed professional engineers.
Other board questions on this? Any problems accepting this witness as an expert?
One set
No.
of questions, one set.
Yes, please.
Normally, the representative would say, have you served as an expert witness in previous forums like this?
No, sir.
Anywhere?
I have not served as an expert witness in the past.
Mr. Chair, can I just observe that quite obviously he's testifying under oath.
What was your, I'm sorry, can you restate that?
I would just observe he's testifying under oath, and unless we think he's lying,
Right, yeah. The board takes that testimony under advisement. Seeing no objection, hearing no objection, tender Mr. Edsel as an expert in engineering with a focus in those areas.
Thank you, Mr. Chairman. Mr. Etzel, were you employed by Mr. Stern to design erosion control and stormwater plans for his access into Dove's Landing?
Yes,
All right, and did you submit that as part of the application for this requested variance?
I did.
All right, and if I can just show you on the screen. Does that document look familiar to you?
That's my seal and signature.
All right, and then there are accompanying documents, pages that we're going to go through, but is this the plan that you submitted for Mr. Stern as it relates to erosion control and stormwater plans?
Yes,
All right, and that's your seal that we're seeing over here right there?
yes, and that's my signature.
And we're going to walk through these plans, hopefully rather quickly. Can you explain to the board what this shows? This is sheet C 0.1.
Yeah, this plan sheet shows the existing conditions of the property prior to the development, shows the existing access road to Mr. Wilkie's property. It shows the approximate location of the stream in question and the buffer. It also shows the existing deeded easement and the property boundaries to Mr. Stern's property. And the contour intervals are provided in 10-foot increments.
All right, and so just to demonstrate your testimony, that what I've just pointed to right there, what is that?
That is Mr. Wilkie's road.
All right, and then this, what I've pointed to right here, what is that?
That is the stream in question.
And then, and it's very, very hard to see. But there's some provisions, or I guess there's some markings that are in green. What does that represent?
The green markings represent the easement.
All right, and how did you determine where that easement was located?
It was located by a professional land surveyor and provided to me.
All right, and so this blue stream basically bisects Mr. Wilkie's access and the proposed access to Mr. Stern's lot.
Yes, sir.
All right, and when you're talking about topographic lines, and you look at this one, are there a difference between what we were just looking at and what we're looking at here?
Yes, these are 2-foot contour interval lines, and the previous map was 10-foot intervals.
All right, and so there's been some discussion. Is this your plan, your seal, and your signature?
Yes.
And as it relates to access down here in this southeast corner, did you look at that? Did you go out and investigate that portion of the property?
Yes, I have physically been to the site and seen that location that we're looking at.
And tell the board about the possibility for access in and around this area.
So this area is one of the steeper parts of the property, as you can see by the proximity of the contours to one another. In addition, this property is in the steep slope overlay, which limits the amount of disturbance and impervious surface within those areas. This area in question here would be extremely difficult, if not completely impossible, to grade a road in to access the proposed home site.
And why do you say that? Why do you give that opinion that it would be extremely difficult, if not impossible?
Because of the existing topography. The angle of the existing slope there is extremely steep, so cutting a flat bench and a drainage channel for a road and a drainage swell would result in cut and fill slopes that would run up to the ridge line.
All right, is that, in your opinion, is that practical for land planning or land development?
No.
And so did you investigate, did you investigate other accesses, appropriate deeded accesses to get to the home site?
When we encountered these challenges, Al and I did discuss alternative access points to his home site, and we did deem that the southern access point where his property touches the road is topographically impractical to access the home site.
So what other alternative did Mr. Stern have, or what other alternative does he have to access his property?
He has the deeded right-of-way that's existed since 1980.
And so when we're talking about that deeded right-of-way, is it this one right here?
Yes.
And have you designed a plan for the installation or the location of the road within inside of that deeded right-of-way?
I have made my best effort to recreate the center line alignment and the grade that exists in the field, and I've provided cut and fill slopes that would result from 2-to-1 fill and 1.5-to-1 cut. However, we also have involved a geotechnical engineer in this project who has certified in a letter that they have observed the existing slope angles which exceed the ones shown in my plan. And they stated in their certified letter that the angles of the graded slopes appeared stable at the time of their visit.
And is it common for someone in your area of practice to rely upon other expert reports related to areas outside of your expertise?
Yes, I defer to geotechs when we get into things that are outside of my realm and in theirs.
And so when we're talking about the actual area that needs the variance, did you go out there and locate the areas that are within 25 or 30 feet of the protected stream?
So the stream as shown on my plans is pulled from publicly available data from NC1 Maps. It provides flow center lines for the state of North Carolina. That's also verified through the topographic contours that it is the low point of the contours. To assume the location of the 30-foot setback, I approximated a 5-foot top of bank offset from the center line, and then a 30-foot offset from the 5-foot top of bank offset.
And why did you need to do that?
As you can see in the notes on this plan, this does say approximate location of existing unnamed stream from USGS topo data. That exact feature was not surveyed, and so therefore I used publicly available data, which I believe to be reasonable to locate that feature.
And is it often that the publicly available information as it relates to the location of the stream, is that something that you commonly rely upon in your area of practice?
It is, and I've verified it through the topography and visual observation.
And so I'm going to mark, is this area in which I'm marking in red, does that approximately locate or show the location of the stream?
Yes.
And when you're looking at that, how did you figure out how much of the roadway encroaches into the 30-foot required stormwater setback?
In this map, if you zoom out, I've hatched the areas that encroach in red to try to make it very clear exactly what portions of the road we're discussing today. And I did that by using the flow center line, as I referenced, offset 5 feet as an assumption for the top of the bank location, and offset 30 feet for the vegetated setback requirement.
And so when you're talking about the red area, you're talking about this area here on the south.
Yes.
Is that right?
That's correct.
And so that area, you've hatched it in red, and so what does that represent? Does that represent that it's within inside that 30-foot buffer?
Yes, that is one of the 2 buffer encroachment areas that we're requesting variance for.
Okay, so as we go north from that hatched red area, the balance of the road until we get to the other hatched red area, is that outside of the 30-foot stream buffer?
It appears to be based on the assumptions we discussed.
And so then we're looking at another request for a variance of this area.
Correct, for that portion of the road inside the buffer.
Now, there are some different looking topo lines that appear to come straight down, straight across in both of those areas. What does that represent?
Can you show me the topo lines you're referring to?
Yep, right there. You see how instead of being kind of offset, they look like they're almost straight.
Yeah, so the dark topo lines are the contours that are generated from a 2-to-1 fill slope and a 1.5-to-1 cut slope. The gray topo lines are the existing topography and the LiDAR contours.
And so is this work that would need to be done in that buffer area, or is this work already done?
So the work is already done, and it's not exactly represented by these contours. To create this plan, I was given survey of the easement area and survey of the road centerline elevations, and then I created a grading plan using those things and using 1.5-to-1 cut slopes and 2-to-1 fill slopes.
All right, and if this site plan, so I just want to be clear, we're only talking about the two areas hashed in red that need the variance.
That's my understanding, correct?
None of the balance of the road that goes along Mr. Stern's property all the way to his home site, none of that is part of this variance request.
That is outside of the buffer and not part of the variance request.
And are you able, in your opinion, will you be able to design a plan which protects the integrity and quality of the stream that is situated between the two access roads?
I feel like that's subjective.
Can you design a plan that adequately protects the stream?
I can provide a plan with erosion control measures and stormwater measures that provides the best protection under low-density requirements possible. I think that's the answer to your question.
Yep. And so does this plan show that what you just testified to was about providing the best possible protections in a low-density development?
This plan does provide reasonable protection for low-density development given the constraints of working in the right-of-way. There are some additional measures that we could provide, like permanent check dams or some additional outlet protection to diffuse water, and we would be glad to provide those things on the final approved plan.
But are those final check dams that you're talking about, could you still install those inside of the deeded right-of-way, or would you have to go outside of the deeded right-of-way?
Those things could be installed within the deeded right-of-way.
Okay, and those would just offer extra protection?
That would be above and beyond protection from what's shown here, yes.
All right. So on your full plan set that we've already gone through, we've talked about the second page. Want to go to this page. What does this show? Can you please identify for the board what this plan sheet 1.0 shows?
This is the erosion and sedimentation control plan sheet. It provides details and specifications for slope matting, channel matting, inlet protection, and outlet protection of the pipes, silt fences, and silt fence outlets.
All right. And that is because is there still additional work that needs to be done?
At this point, it's my opinion that the grading work is largely complete for the road. And this plan, as I mentioned, was my attempt to recreate a grading plan that could be used for compliance with Buncombe County ordinances.
And have you submitted this to Buncombe County?
This has been submitted.
And has it been accepted for compliance with Buncombe County ordinances?
For erosion control, yes. For stormwater, no.
All right. And the reason, can you tell the board why for stormwater it hasn't been accepted?
It's not been accepted because in low-density development, you're not allowed to have impervious surface in the stream buffer.
And that's the exact reason why we're here, seeking the variance.
Correct.
All right. Did you investigate Mr. Stearns, any other legal access that he has as of today?
As we discussed, Alan and I talked about the southern portion of the property where he does have access to the road, but that is topographically restrictive to get access to the proposed home site.
All right. On this page, and we can briefly talk about sheet C 1.1, what does this represent, if you can testify to the board?
These are Buncombe County standard details for inlet and outlet protection, silt fence, sorry, no outlet protection, just inlet protection, silt fence, and silt fence outlets, and a standard driveway cross-section.
And as it relates to erosion control and silt fences, that's already been submitted and approved by the county?
Correct.
Next page that you have, C 1.2, if you can explain briefly what this page represents for the board?
These are additional standard specifications for erosion control practices, construction entrance, slope and channel matting, temporary and permanent seeding, soil stockpile, and a construction sequence.
All right, and it talks about seeding. Has that been done, or are you in the process of doing it?
I don't personally do any of the work. I'm just a designer, and I can't state whether or not it has been done or not.
All right. And this page, I'm just showing you 1.3.
So when you disturb over an acre in addition to the Buncombe County erosion control permit, you also have to get a state NCGO 1 permit. And these are North Carolina statewide rules, and this page and the one after it are standard state requirements for those erosion control plans.
All right. Is that something you assist Mr. Stern with in applying for and receiving?
Correct, yes.
All right. Have you done that yet?
It's been about a year, so I can't remember if the NCGO 1 has been applied for or not.
All right. This next page that I've just got up there talks about profile view of the roadway. Tell briefly, if you can tell the board what that is and what it represents.
Sure, if you could zoom in on it a little bit more. This is a center line profile view of the proposed and existing driveway alignment. You can see the center line slopes are denoted on the plan, and they range from 15 to 16 to almost 17, which is on the upper limit of the center line slopes that I would recommend. And that further shows that even in this location, the topography is still challenging to get a road at a reasonable center line grade, and any other locations are going to be much more challenging than this.
And is there limits on the percentage slope that Buncombe County has for the installation of a driveway road?
It's my understanding that they do not have standards for personal private driveways, but for Buncombe County subdivision road standards, I believe the maximum centerline road grade would be 18%.
And in that area on the southeast corner that we were talking about, that Mr. Stern's property borders the roadway, does that area exceed that 18%?
The natural topography in those areas is between 30 and 60%.
All right. And based upon your training and experience and qualifications for grading and erosion and land planning, is it practical to put a road in such a steep topographical area?
It's extremely challenging, usually results in a lot of retaining walls, if it's even possible at all.
So I think we've gone through a couple of these already, so we'll try to make it quick. What is this one, if you can describe this 3.0 for the board?
This is the stormwater plan, and this plan provides design for ditches, pipes, and pipes to convey the 25-year storm, and also for pipe detention to provide peak flow attenuation of the 1-year, 24-hour storm.
And is that what are your design standards required to design to the 25-year storm and that peak flow?
That's the low density requirement, yes.
Okay. And does this drawing C3.0, does it comply with, to the best of your knowledge, comply with those peak flow and 25-year storm events?
It does provide those, yes.
And then this next one, is that again some additional stormwater control measures?
Yeah, this is a pipe detention detail, and this feature captures runoff from impervious surface and detains it in this piece of pipe and releases it at a rate to match the pre-development runoff rate in the 1-year, 24-hour storm.
Is that going to be a requirement for the development of this property to not exceed the pre-construction runoff with post-construction runoff?
For the 1-year storm and low-density development, yes.
Yes, and applying these design criteria and standards, in your opinion, would that satisfy that requirement?
These features meet the low-density requirement for peak flow attenuation.
We've talked about this. Is there anything additional that you want to tell the board about what this design map shows?
This map shows pre-development drainage areas, basically where water flows on this property prior to development and where water leaves the property. And then the next page shows the drainage areas in a post-development condition to demonstrate that we're not moving water from one natural drainage basin to another in excess of the allowable limitations.
All right, and this shows that, so you've satisfied all of that?
Yes, sir.
All right, so again, you're talking about two areas that would require a variance. I've highlighted one, and the other one's down here. Is that correct?
Yes.
And the need for that is because through the deeded access that he has, that you've testified about, those areas encroach within that 30-foot buffer.
That's correct.
All right. Applying all of your stormwater and erosion control measures, do you have an opinion as to whether this would protect the health, safety, and welfare of individuals in that area? I mean, does it satisfy the Buncombe County requirements such that you satisfy all of the necessary requirements for development?
So the encroachment of the impervious surface in the buffer does not meet the low density requirements. However, the other requirements are met through this plan.
Without the variance, if the variance is denied, do you know what the practical result of that would be from a land planning perspective?
If the variance is denied, then Al has the opportunity to redesign his project as high density, which requires water quality treatment first inch of runoff from the site and changes the design criteria. And that would allow the impervious surface to be constructed in the buffer, but it would add cost and additional measures and time to the project.
All right. Is this a high-density project?
The threshold for high density is 2 units per acre, greater than 24% built upon area, and this is a low density project.
And is this proposal one house per 10 acres?
Yes, one structure per 10 acres, which is low density development, as opposed to 2 per 1 acre in high density.
Okay. Those would be all of my questions of Mr. Etzel.
Thank you very much. Mr. Wilkie, questions? For Mr. Stern? For Mr. Edsel, I'm sorry.
I'm not sure I heard you correctly. You mentioned that it does not meet the low density requirements for what aspect of this?
We're requesting the variance for impervious surface in the stream buffer, which is the low density requirement that we cannot meet through this plan.
You cannot meet it. You never looked at any other alternative routes up in there, did you?
We did. We investigated the southern route where Mr. Stern's property touches the road and determined it was topographically infeasible.
Is that the only other option you looked at?
That is the only other option that he has on his property as it's currently configured.
Okay. What is as far as creating a steep slope from grading, is there a limit that's allowed to that as far as the pitch goes?
General design guidance is 2-to-1 fill and 1.5-to-1 cut, and angles in excess of that require geotechnical evaluation and approval.
And is that just for safety? It's just the stability of the slope?
It's for slope stability, yes, and preventing erosion of the slope.
And what is the pitch? As you go through and make that left turn, I'm saying it's about a 120-degree turn. There's a wall there that's graded out. What is the pitch of that wall?
I could not tell you exactly. Well, as I mentioned, we do have a geotechnical evaluation that looked at those slopes.
And he determined they were just stable.
His report said that at the time of his visits, the slope he observed appears stable.
Is there a limit as far as the height? When you cut into the side of a mountain, the height of the wall that you create, is there a limit to that?
I think it's general design guidance that when you exceed 20 vertical feet, that you bench the slope, and applying a bench before you continue with the cut slope.
I understand. Is this more than 20 feet?
I cannot tell you how tall the existing cut slopes are at the site right now.
So you don't know that, I mean, it very well could exceed the 20 feet and require a bench that does not exist. Has that not been looked at?
The geotechnical report states the heights of the slopes, if we could add it to the case if you wanted to, or, I have not measured the height of the slopes myself.
What was that maximum height again before the bench? I'm sorry.
I think it's general design guidance to have 20 vertical feet before you install a bench in a slope.
If, I mean, you're familiar with grading work that's done by others, but I mean, I assume you supervise that or design it from time to time. Is that?
Yeah, I design and oversee grading projects.
In your opinion, did this machine operator do a reasonably good job of setting the road foundation against the land?
That's a little bit of a tough question for me to answer about the road foundation itself. I feel like that's more of a geotechnical compaction question that I can't.
Well, let me ask
state
it in
to.
a different way. If he had started gaining elevation earlier, like where it came through the intersection down there where the driveways, there's a confluence of roadways there.
Mm-hmm.
If he had started bringing that road up higher so that when he got to that 120, I'm calling it a 120-degree turn. I think you know what I'm talking about. I
Yeah,
don't know
the
that it's
switchback.
120 degrees, but
Yeah.
switchback. If he had started raising that at that point, could he not have kept the road further away from the creek?
Not while staying within his deeded right-of-way.
Would it make sense to have started climbing before he did so that you wouldn't have that?
There are a few different ways the road could have been graded, but it was extremely limited by the right-of-way location and width and the presence of an existing logging road.
Well, there comes a point where it's totally on Mr. Stern's property.
And at that point, it's outside of the stream buffer and not part of this variance.
Okay. It does diverge, I see that.
The two sections where the encroachment is in the stream buffer would have been impossible to create outside of the stream buffer due to the location of the right-of-way.
Do you have any idea if a permit had been applied for before the work was done? Do you think this would have been approved? Is that a fair question?
I think we would be at the same place we are today, where we would still not be able to get the stormwater permit approved as a low-density project due to the impervious surface in the stream buffer.
Okay, that's.
Thanks.
If you found out that that bank, once you go through the switchback, if you found out that that bank was more than 20 feet, would that be a problem for you?
That would not be part of this variance hearing because it's not in the stream buffer and not what we're here to talk about.
But as far as meeting requirements of generally accepted grading practices, would that, I mean, if it was 30 feet, if it was 30 feet high, what would need to be done at that point?
A geotechnical engineer would need to provide a certified letter evaluating that slope.
But in your experience, Buncombe County would accept that if a geotech signed off on it, you think they would approve that?
It's my opinion that if a licensed professional engineer with a geotechnical background provided that certified letter, that Buncombe County would probably approve that.
Okay. Okay.
Thank you, sir. Mr. Maselli.
All right, thank you. Mr. Etzel, so I just want to make sure I heard you correctly. So did you say with the grading that was done, is there already impervious, like a slope basically down into the buffer already?
So the impervious surface goes on the road bed.
Okay.
And I don't know, I can't say or not whether there was gravel added to that road or not. Like I said, it's been over a year since I've been out there.
Oh, okay, that was actually going to be one of my next questions. So it's been over a year since your visit to the site?
I visited the site on 2 different occasions, and they were both quite some time ago,
Do you know roughly the time frame?
approximately a year ago.
Approximately a year ago, okay. So you're familiar with, obviously, erosion control measures that need to be taken, correct?
Correct.
Okay. I know this has been almost a year. Did you see erosion control measures in place, and were they acceptable?
At the time of my visit, the erosion control measures were not installed in accordance with these plans because these plans had not been developed at that time.
Understood, but there was, during your visit, you observed the grading that had taken place, correct?
Yes, I observed the grading that was done.
Okay. I don't know is it possible for me to admit a document into evidence? Or?
It is.
Okay. Yeah, I'd like to admit this, this notice of
Hold,
violation.
hold
into
on,
evidence.
before you
Pass
admit
it.
it, first thing you need to do is show it to Mr. Goulden and give a copy to the witness and have the witness identify what you're trying to admit.
Okay, thank you. And yeah, that is via public records request. That is directly from Buncombe County.
Hold on, can you give a copy to the witness so that the witness knows what you're talking about?
May I take a quick look at it?
It'd be stapled. Sorry, I didn't prepare enough copies here. I have a second copy.
Do you have enough copies?
I have 2 physical copies, and then I also have it available digitally as well.
Pass it around, yeah.
It's a do you want us to make a copy for the board?
I think we can pass one copy around.
Okay, I will go make a copy.
You can also have my copy because I have seen this document before.
Well, there,
I'm familiar with it.
I'll take yours.
without objection, we can admit it.
You all can continue to ask questions.
Okay, yeah, I'll move on. So during your time there, I think you just stated that you didn't see any erosion control measures that were implemented, correct?
I did not say that.
Okay. Oh, okay. Were there any erosion control measures that were implemented, and would they have been compliant?
I've been to over 100 job sites since I was at this one, so it's really hard for me to remember the details of this site visit.
Okay, so you're not familiar, you can't really speak to the details of this site visit?
As I stated, it's been over a year since I visited the site, and I've looked at well over 100 jobs since then, and so it's difficult for me to remember the details of this very specific site
If you've
visit.
got a detailed question about it, you can ask that at this time.
Yeah, well, I did specifically about the erosion control measures that were in place, but it also raises concern if you're not familiar, or you've been to over 100 sites, and you just said you're not that
I have
familiar with this
photos.
site.
Well, the answer, that question wasn't asked and
Yeah.
answered, wasn't answered
Yeah,
twice,
so
that he
it
did
raises
not know.
concern about the other observations from the site visit. Did you
Well,
ever
objection, move
explore
to
the?
strike. That wasn't a, that wasn't a.
Did you,
question.
I'm
We'll
asking a
strike
question.
that. It's
Yeah.
we'll strike that, and it's overruled, yeah.
Right, sorry. Did you explore the western boundary of the plat for potential roadway?
There is no deeded access on the western side of the property.
That's not my question, though, but did you explore that?
We did not because there is no deeded access there.
Okay. You mentioned steep slope overlay. So you said during this, investigating the southeastern potential access, you mentioned the concern there was that, or one of the concerns was it crosses steep slope overlays, correct?
Correct.
Okay. Does the existing excavated roadway cross any steep slope overlays?
I believe it does, yes.
Yeah, okay, so it also crosses steep slope overlays?
Yes.
Okay. The stream that's kind of in question here, are you aware that that's a designated trout stream?
I am aware. I think it's a first-tier tributary to a trout stream.
Okay, good, very good. Okay. Erosion control measures, I think that's all for now. Thank you so much for answering my questions.
Yes.
Thank you very much, and you redirect.
No redirect. Well, strike that, just one. The one area that we're talking about, that sharp corner where Mr. Wilkie was talking about the height of that slope, that's outside of the variance request area.
That's correct.
Okay, those would be my questions.
Thank you. Moving to board questions. Mr. Etzel. Please.
So looking at the subdivision plat, would everybody have the same issue that your client has for getting access to the property, anything above that kind of the curve?
Thank you.
You know, before the split?
As far as the encroachment into the buffer,
Yes.
yeah, any use of this deeded right-of-way is going to result in some encroachment into that buffer.
Okay, so anybody above that is going to have it. So it looks like there's 1, 2, 3, 4, 5 properties above it?
So Mr. Wilkie's other properties are served by an existing road that's already in the buffer.
Okay. Another thing is, would, you know, so Mr. Wilkie has offered that he has solutions to go from his land over. Is that a reasonable thing that your client could potentially do? Or, you know, I know you haven't considered it, but it's like if you considered it now, would it be
I
feasible?
would need to look at the topography and prepare a grading plan to determine the feasibility of access through that point.
Okay, and then my last question is, if he doesn't get the variance today, would your recommendation be that he go for the high-density 2 or more houses for that space?
If the variance isn't granted, that would be the only option to use this existing deeded easement, and it would change the scope of the project.
Okay.
Carol.
At one point, you said, the quote was, it meets the measures. That was a little bit later, but before that, you said additional measures could be provided. What did you mean by that?
So this plan meets the requirements for peak flow attenuation and for conveying the 25-year storm in the ditches and the pipes, which are the design standards. And I was asked if there are other measures to protect water quality, and there are some other measures that could be added in addition to the minimum required measures to additionally protect water quality.
Okay. Have you visited the site since Hurricane Helene?
No, ma'am.
knowing what you know about Hurricane Helene, is there any chance your evaluation would change because of that storm?
Unfortunately, the access in this deeded right-of-way is so restrictive, there really aren't other options for locating this road.
That leads me to my next question, actually. Through the deeded access, if an easement would be granted over other parts of the property, I think somebody else just asked that, maybe it was you. Would there be any other viable way to construct a road to give Mr. Stern access to his property? Or maybe that was you.
I would have to do some additional analysis to be able to determine if it's feasible to access this build site any other way. But at this point, I've only evaluated the existing deeded access and the road frontage access that Mr. Stern has.
I think we had a question over here. Joel, do you have one?
It came up a few times about geotechnical, valuation. Is there a report regarding that?
There was a geotechnical evaluation and report issued.
I have one more question. I'm looking at this document, which is more extensive than I anticipated, the notice of violations. This one concerns me. Failure to file an erosion and sedimentation control plan with this office 30 or more days prior to blah, blah, blah. So have you now filed the erosion and sedimentation control plan?
Yes, that's the document we just reviewed, and it was filed with Buncombe County in response to the letter that you have.
All right, thank you.
Mr. Maselli, do you want to enter the NOVs as evidence on the record?
I'm sorry, say again, the MO?
The document that you submitted.
Oh, absolutely, yes.
Brian, do you have any objection?
No, I think it's a public record.
Okay.
And may I, is it possible to add to that question, or?
Hold on.
or-
Yes.
Okay, yeah, so the
Well, is he
document.
testifying? He hadn't been.
Oh, I'm sorry.
He's not
No,
testifying.
he's not testifying, no.
Okay, I
think
thought,
he's
I thought he
asking-
said,
I
could
think
he
he's
respond
He's
to the
adding it,
question?
he's
Yeah, I
adding
think he's
information to
asking
the
a
submission
question.
document.
Okay, I
Yeah.
misunderstood.
Yeah, absolutely. So, you did have a chance to review that notice, correct?
I received it back in
Okay.
2023.
Okay, yeah, so, the references in that document are related to not to your plan, correct?
That's correct. My plan is in response to that document.
Very good, and the measures, erosion control measures within your plan have not been executed, correct?
They have been approved by Buncombe County, but cannot speak to what's been done on the site since my last visit.
Okay, thank you.
And Mr. Wilkie, any questions for the applicant on the NOVs, the document that was passed around?
Questions for the engineer?
On that, on the NOVs, yes.
Not the violation document.
No.
Okay, thank you. And, yeah, we have more question.
Okay, so you heard Victoria's testimony, right?
Yes, ma'am.
How will you address what her concerns were?
Could she repeat her concerns?
Is it working? I don't need to do anything special with y'all, right?
No, you're sworn in.
You're good to go.
All right, cool. So the concerns were, and I think Wyatt did a great job of summarizing it. The concerns from a stormwater permitting perspective are that this meets the threshold for low density. However, they cannot meet the low density water quality requirements, which require them to not have impervious area in the buffer. And we have that policy to allow that perpendicular crossing with some additional requirements there, which would just not apply to this project because it's a parallel encroachment, not a perpendicular encroachment. So there are options that we presented in our comment letter. So we issued a comment letter that had various technical things that need to be addressed that I have no concerns about whether they'll be able to address except for this one that this variance hearing is about. And the only way to address that is to either get a variance or redesign the site to meet high-density standards. And so that's really where, from a permitting perspective, we are kind of stuck right now, is can the site be redesigned to meet high-density standards, which would allow this impervious area encroachment within the buffer? Is that technically feasible? I have not gotten final confirmation whether that's even technically feasible. There are, I will go ahead and say that there are some technical concerns with that. There may be some barriers to that, you know, Wyatt might be able to speak to, as to whether that's a viable option. If that is not an option, the only option would be for them to obtain a variance.
And the water quality piece of that is there because we are looking at an encroachment that's parallel with the area that we're talking about, the
So
zone.
the stream buffers so stream buffers do exist in high-density regulations as well. There's just an exception that the General Assembly passed several years ago that allows impervious area to be placed in the buffer if it's treated. I won't get into the details. Unless you want them, and then I'm happy to get into the details. But
Is it because of the risk, a higher risk of road failure, of slope failure? Or is it because of an environmental particular
It's an environment, it's a
condition?
water quality protection measure. So in low-density water quality regulations, you have to maintain your vegetated setbacks and then try to not concentrate the stormwater runoff. And where you do have to concentrate it, you convey it to the maximum extent practicable in vegetated conveyances, because that allows more infiltration, kind of protects the natural hydrology of the site, which is more feasible in low-density environments. In high-density environments, you collect the stormwater runoff and treat it through a water quality treatment device to clean the water of typically around here it's sediment, in other parts of the state it's nutrients as well, but here it's sediment, so that we're not contributing to further pollution. In trout waters such as this, we also have the requirement to cool down the water, because we do not want hot water being discharged into our streams, because that will, you know, impair the ability of the trout to live there. And so that's another reason why the impervious area has to be treated prior to discharge for high-density environments, and why we need that built-upon area to be outside of the buffer, is to protect that water quality, and in trout watersheds for the trout, but in other watersheds for just general habitat and environmental quality. And those regulations are pretty much exclusively derived from NCDEQ. We just follow
Very
their
helpful.
guidance there.
Thank you.
May I ask?
So there-
Yeah, one question, can I ask?
Before we do anything else, there's two sort of questions there. One about whether if we stay in the current phase, you know, about the dispersion and water quality issue. And then the second one was the feasibility of moving to phase two.
Sure.
And what that would,
I can speak to those.
Right.
Yeah, so,
Is it possible for me to ask Victoria just a question on what you just
after
said?
we hear this response, yeah.
yeah, so, the current measures do meet the low-density requirements except for the encroachment into the buffer. And as I mentioned previously, additional measures could be provided, such as permanent check dams, which could provide an additional level of water quality protection in addition to what's provided here. But it would not eliminate the need for the variance because it would not remove the impervious surface from the buffer. So if the variance is permitted, we could provide a couple more measures that would provide additional water quality treatment beyond the minimum low density standards. But we can't remove that impervious surface from the buffer. And
If that part of the variance were approved by the board today, could you all work on the other two pieces, on water quality and?
yes, sir. Yes, and Victoria and I have had an email correspondence about those additional measures that could be added, but it's a moot point if the variance is not approved, because the impervious surface exists. And then to the second point about high-density development, that would require stormwater control measures to be installed within the right-of-way, which during my initial submission, Victoria mentioned that we would need to provide documentation that the right-of-way language allowed for the installation of those measures. And it's my understanding when Al approached Mr. Wilkie, he said he would not allow those measures in the right-of-way on his property. And the language was not specific in it to state that they were allowed.
So if I'm hearing you correctly, you did actually try alternative routes, and Mr. Wilkie was not amenable to those.
I did not personally speak to him, but I have correspondence through Al that we requested stormwater control measures in the right-of-way and they were denied. And so we designed the project to provide compliance with the low density requirements where all the stormwater control measures are outside of the right-of-way on Bill's property.
Crystal clear? No.
Yeah, just to be clear on something, you had mentioned needing a variance in your testimony. We're talking about the variance we're hearing right now, as opposed to some other variance.
Yes, yeah, so yes, so it's the, if the driveway needs to be placed in that easement, which it's up to them to demonstrate that, then the only way to compliantly get that driveway in that easement where it's currently located is to either design the site for high-density regulations or approve this variance to allow that with or without whatever conditions you guys would want to put on it.
Other board questions?
Yeah, just-
Mr. Edsel?
So for your perspective, Victoria, what, if we approve the variance, what would conditions look like? Besides you two work out the 2 points, the
Yeah.
dam thing and,
So the primary concern here, from my professional opinion, is the trout designation. It's cooling that water down, making sure that we're not direct discharging runoff from the hot gravel driveway into the stream without having some intermediate measures to slow it down, cool it down, infiltrate it, spread it out, all that stuff. To the extent practicable, if it's possible to put permeable pavers in the driveway where it's in the buffer, that is something that might be worth exploring. I don't know if the grades are prohibitive. We do not get a lot of permeable pavement designs in Buncombe County, and where we do, it's usually flat. I know that there are provisions for installing on slope, but I do not know if the grades here prohibit that, but that would be something so that's why there are options, but there may be technical challenges, and so whatever condition was put on there, I would suggest having enough clarity so that we can enforce it, but not too much that we're proposing technical options that may not be viable.
and would Mr. Wilkie have to agree to that too? Or
Or
is it with the right-of-way, does that,
there might be permeable pavement options that do not need to be classified as a stormwater control measure, that would not have significant ongoing maintenance needs and need to be, and would not, yeah, I think that there could be options explored that do not require that would be covered by general right-of-way and easements. Now, I have not reviewed the terms of the right-of-way and easement agreements, and I am not an attorney, so even if I had, I would not be qualified to speculate on what's covered by them. But there probably are. But again, without, them having a chance to really review the terms of whatever the agreements are in place, if there are even agreements in place that are deeded, or if it's just platted, I can't really say for sure. But yes, there are potential options that could protect water quality to the maximum extent practicable, that could be added.
Is it possible to ask one question to Victoria?
Let's wait until, it's board deliberation time right now. Let's wait until your presentation.
I
there's
would
some evidence.
suggest if one of the parties, I think that
You think?
Victoria was responding to a board member question, but if one of the parties wants to call Victoria or recall Victoria, you would have that option.
At this time, or?
Well, no,
Later.
not at this time.
In a minute,
Okay,
yeah.
okay, I just figured.
We'll get to it, yeah.
Thanks.
Just for clarity, what's the final surface of the drive? What's the planned final surface?
At this point, I think it's proposed to be gravel, but Al could probably state better than I could what the end goal is.
And Victoria, your assumption is in order to mitigate the heat, you were basing that on the fact that it was a gravel drive.
Any paved surface, so gravel's actually probably one of the better ones, maybe
Right.
concrete might be a little bit better. But gravel tends to allow some water infiltration or slow down because it's not flat,
Okay.
whereas concrete and asphalt just absorb the heat, sheet flow off, and then carry that heat with them into the stream if appropriate mitigation measures are not put in place.
Other board questions? Hearing none, thank you, sir, very much.
Thank you.
And Mr. Wilkie, if you're ready, we can go ahead and hear from you on your testimony.
Brian, did you have any other witnesses?
No, that was it.
Oh, sorry, Brian.
Okay.
I
No,
assumed-
that's all right. I think I
assumed, yeah.
said that.
I just wanted to.
Yeah, he said one more, so yeah.
The, part of all this that's so frustrating to me is, another much better, much easier, much cheaper route for a driveway was offered, and I have an affidavit here I would like to submit to the board.
Okay, pass it to.
Yeah, well, we'll object to that. It's not an affidavit from Mr. Wilkie.
It's a statement.
It-
I'll just say it's a statement.
Yeah, but it's not a statement from Mr. Wilkie. It's from a gentleman named Keith Florence. It's not in front of a notary. Nothing is signed to verify that it's his statement, so we would absolutely object to that coming in. It's complete hearsay without the right to confront and cross-examine this witness.
Before ruling on that, Mr. Wilkie, who is this gentleman?
I'm sorry?
Who is the gentleman who wrote the document?
The gentleman is a local grading contractor who talked to Mr. Stern and then subsequently met with me regarding the alternative driveway.
Yeah, he's not here to be able to cross-examine, so we can't take
Yeah,
hearsay, but,
I would think that that's almost hearsay on hearsay.
right. But we can't-
So,
we
no,
can't- Kurt, what can we do here?
well, I mean, if Mr. Wilkie has any, he can testify to, I mean, were you present at the conversation when this happened?
Yes, absolutely.
I mean, it would be your discretion, but I think you're getting into a very dangerous area where, he can't testify to what somebody else said. He can testify to his impressions of the conversation.
The conversation between this professional was with you and him directly, or was anybody else there?
Me and him directly.
And then he went back, you think, and talked with the applicant?
He states that he went back and talked
Okay,
to Stern and made it clear, but.
That part's not
but
gonna be.
I did not witness him going back and talking to Stern.
Yeah, that part where he talks to
but-
Mr. Stern is not gonna be applicable, it's not gonna be admissible.
I spoke with Al Stern and told him about two options. One he has rejected. He
Yeah,
thought it was too steep.
That part can be part of your testimony today, yeah, absolutely, but
So-
not somebody else's
So
conversation.
are you at this point going to give your testimony regarding
Yes,
this
yes,
case?
I'll
And you can do
Okay.
that, you can do that now. You can
So
do it
once
verbally
again, you
without-
can
without
testify to
submitting.
impressions, but you can't testify to what somebody else said. Like you can't say that I,
what they told me.
well, you said that I talked to the grading as a hypothetical, you can't say that the grading contractors, or Mr. Florence said to me X, Y, and Z.
That
But
his
you
opinion
can
was
see
this.
that I had a conversation with Mr. Florence and and this is what I took away from that.
Yeah. Yeah, you can do that verbally, of course, yeah. Thank you.
The problem I have is that Mr. Florence had he's also a neighbor, he had substantial damage to his home, which is not livable at the moment, and he's in Kentucky. I'll be happy to have a deposition or get him down here if need to be, if I can delay this, but I would like to tell you what the conversation was. I mean,
And we're gonna object. It's a conversation that he is saying Mr. Florence had with Mr. Stern. That-
well, let me,
The board, okay, that's going to be, the board is okay hearing about your conversation with the contractor, but not any details about the conversation between the contractor and Mr. Stern.
okay.
That makes sense?
My
That makes sense?
conversation with the contractor,
Yeah, that's right.
with the grading contractor.
Okay.
Yeah, that's fine.
Thank you.
Referring to this document, which shows all 6 lots, I believe this has already been submitted.
One, yeah, I did. I pulled it up, if I can get it on the screen.
Where the main driveway for Dove's Landing connects to Old Fort Road, There's approximately 3 acres, 4 acres to the left of that driveway. That's my property. I offered that easement through there to Al Stern years ago. When I met with the contractor, it was in November or December of 2022. It's been 2.5 years.
Okay.
But the contractor had, I don't know what I'm allowed to say. I offered it to Al, verbally I offered it to Al.
For purchase or for easement?
I offered the other much better driveway location before any grading started.
Objection to him testifying it's much better. He can testify that he offered it to him.
The board
okay.
can- no,
I
that's-
offered an easement to him.
Yeah, sustain, yeah. You can go ahead, sir. The board can, the board can take the testimony as they will and weight it appropriately, so.
I mentioned to Al Stern that I would trade with him and he could have an easement coming real close to Old Fort Road across that 3 or 4 acre tract to the left of the driveway up into his property. It would be lesser of a grade. It would stay far away from any stream. Subsequent, my conversation with Al Stern, when I mentioned that to him, a grading contractor called me. Keith Florence and his associate called me and wanted to meet with me at Al Stern. They told me, well, at Al Stern's request. They said,
We're going to
that
object
they
to
asked to meet with me to check this out, this potential. They looked at it and they said they would recommend that.
Well, objection to what they said.
He's talking about, he's overruled his conversation.
This is my conversation
His
with-
recounting of conversation with the contractor is appropriate, yeah.
It is appropriate.
It is
for me
appropriate, you can go into that.
Okay. Well, he told me it would be much better. And,
Then,
simpler and
sorry,
cheaper.
then, better than what?
Then the right-of-way, the existing right-of-way
Okay.
that goes through that switchback. He said this would be better, cheaper.
Well, objection, talking about better and cheaper, he's not an expert, he hasn't been qualified as an expert, we don't know what his experience is in grading, and he's talking about what someone else who's not here for me to confront and cross-examine is talking about a location of a hypothetical road that was offered. There's nothing in writing.
Yeah.
He's never offered it, and so he's talking about a hypothetical area, about some hypothetical person. I just have to object to that, I apologize.
The
Well,
board's
then
been
let me-
instructed, the
let-
board's,
let me
sir,
speak-
hold on. The board's been instructed to take with appropriate weight what it has said.
Well, let me make one
and
final
so
statement to the board.
you can continue
if I
with that.
can.
Yes.
I offered this. It has always been on the table. I mean, the grading did start in June of 2023. It's been 2 years since the grading started, but this was never taken off of the table. If this other one, I mean, I'm telling you, it's always been there. It's there now. I've never rescinded that offer. He could come off of the road, off of the main driveway, very close to Old Fort Road. There is plenty of room. It is not steep. It is a southern exposure. It is much safer.
So
And-
with what Victoria's offering, would you accept that offer?
I'm sorry?
With what Victoria's suggesting and offering, would you accept that offer?
That's not related to this left parcel at all. It's
Yeah,
to the- to the-
that's,
yeah.
He's offering only one option, and it's like, I have this one offer, that's all.
I think it's absolutely
Victoria-
appropriate. We're talking about trying to get a transfer of property in writing. He doesn't have it. It's not signed by him. This is all hypothetical. I think the question goes directly to what the variance is. Victoria said we could do these other conditions, but it would have to be on Mr. Wilkie's property. I think that question is appropriate for a person who's testifying from the board.
well, and I would argue that because this was offered and is offered, and he chose not to take it, then the problems that he has now in asking for a variance are problems of his own making. He could have avoided all this and wouldn't be asking for a variance at all if he had stayed away from the creek and taken this offer.
Okay, you may continue.
I'm sorry.
If you have more, you may present it. You made that point. If you want to continue your presentation
Well,
or making other statements.
I guess that's all I've got.
I know.
The offer stands.
Are you finished with your remarks today?
I'm finished.
You finished, yeah.
Can I just ask a couple
We
of
cross,
questions?
yeah.
Yeah, and if I could just put up the screen again. So what I've pulled up, Mr. Wilkie, you'll recognize this, right? Echo Lake to the south, your property to the north.
Yes.
You see that? Does that fairly and accurately represent the location of your property on which you're talking about offering a roadway?
Yes.
All right, you see I've put the topographic lines on there? You see, do you recognize those as being topographical lines that are part of the Buncombe County GIS services? If you'll look up there.
You got to recenter this. Yeah.
Is it 5 foot?
It's 5 foot.
5 foot. And so you're saying this area that's, whoops, right in here is not steep?
If you tried to go straight up the hill, it would be. Of course it would. But you've got a long way to travel.
Make sure we're still speaking in the microphone, even if we're standing up, because we've got to have everything on the recorded. Thank you.
Thank you, Mr. Carnes, I appreciate it.
I don't have a topo. Of course, you're going to be climbing, and you're going to cross the grades, but no, if you're not going to go straight up. You can follow the contours and slowly work your way up the hill. It would be less steep than the road that exists.
And you're saying that you've offered that easement. Have you recorded that easement in the exact location of where you would permit it to go?
It was his choice.
Have you recorded an easement in the
No.
exact location of where it would go?
No.
So there is no easement across this portion of the property that you're talking about?
There was the offering of him to choose a place there.
Is
And I'm
there-
saying he did not take it.
We've answered this question.
Is
No.
there an easement across your
No,
property?
there's not one there.
Are you contending that this board has authority to require you to record an easement in favor of Mr. Stern? Is that what you're contending? That this board has the authority to require you to transfer property to Mr. Stern?
I'm pointing out.
I'm just
primary-
asking you a question. Do you contend this board?
No, the board does not have that authority.
Okay.
But in his application for this variance, he says that the neighbor did not give him an option, gave him no option other than the existing easement. And I'm telling you, that is patently untrue. It is a falsehood.
Those would be my questions of Mr. Wilkie.
Thank you. Mr. Maselli, any questions for Mr. Wilkie?
Yeah. Not necessarily for Mr. Wilkie, but regarding what Mr. Wilkie said.
No.
No,
Or
no.
this
You
document.
just,
You're
if you
crossing.
don't have any questions
For
for
Mr.
Mr. Wilkie, then you can pass the witness.
So, yeah, Mr. Wilkie, did you deny Mr. Stern access to that western, a right-of-way to that western portion of his plat that you were just discussing?
Well,
Did you
it's-
deny
it's-
access to
It's
him?
not his,
Is that appropriate?
I'm not sure I understand. the
Can you
question.
rephrase? It's awkwardly worded. Yeah.
Yeah, absolutely. So, Mr. Wilkie, you've stated that you offered an additional potential right-of-way to Mr. Stern, correct?
That's correct.
Okay. Thank you. That's all I have for Mr. Wilkie.
Thank you so much. At this time, if there's no redirect, we'll pause before Mr. Maselli's presentation.
I make a motion that it's time
Well,
to
before,
adjourn.
hold on, before you motion. if we're going forward, but we're not. It's 4 o'clock. I have a hard stop at 4 o'clock, so we got to continue this, this case, of course, due to time. I would encourage, and I think the chair sentiment amongst the board, that there should be conversations this month before this case is brought up again next month between the parties on this other option, to see if it's feasible.
No, on the option that Victoria has offered, not your
Victoria's, so,
I think they should talk about
options in general.
whatever options they can work out.
That's right.
They may
Yeah.
get themselves out of this hearing room.
right,
That's
so
what I
if there's an option on the, another access for a road, then, between the parties, then that can absolve us of a need for a variance here.
And maybe there needs to be a third answer, nothing that we've discussed today. But I think people need to get out of their stances and start coming together, because you guys all have to live together.
So we'll have those conversations hopefully next month and see if we need to come back. But if we do, we'll rule on the elements of this particular variance, and we've got 2 different areas to consider within that, so.
So,
Make a
look,
Is there a motion?
are you saying that we should adjourn today, and then hopefully they get together and chat, and then we?
That's the hope.
resume?
Exactly.
Okay.
And at this time, a motion to continue the case would be appropriate. Yes,
I made a motion to continue the case.
To next month's,
we got it.
the date certain.
Date certain, yes.
So,
Regular meeting.
Second that.
what is that date? July 9th.
July 9th. Same time, same. There's been a motion. Is there a second?
Yes, second.
Thank you, Jeff. Over here.
And we'll
There's
pick
been a
up
motion and a
where-
second. All those in favor, please say aye.
Aye.
Aye. Any opposed, nay?
Yes.
That passes. Thank you very much.
We
We have
sti-
one more case to talk with staff about. It's AK and RS Investments
Do you need that to-
variance.
or just-
So,
Okay, so that one, there's not a date certain as to when, they're not, I don't think they're ready to go, so if you can just continue that case,
Okay.
we'll re-advertise it and put it on the agenda when they get their
But we haven't
packets.
heard back today
For the number
since
of-
we started.
The third case will move, I make a motion to move to a date uncertain.
There's been a motion. Is there a second? For discussion purposes, have we heard back from that applicant today during our meeting?
No.
that we
I
know
don't-
of?
I don't think that they were,
Okay.
nobody was planning on attending.
They told us they weren't coming. Gotcha. Thank you. There's been a motion and a second. All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? Thank you so much. Any other business before the board? Hearing none. Motion to adjourn?
I make a motion to adjourn.
Is there a second?
Second?
All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you. We're adjourned.